Ladies and gentlemen, I welcome you at the Aristotle University of Thessaloniki. I kindly ask the Dean of the Faculty of Law of Aristotle University of Thessaloniki, Professor Panagiotis Glavinis, to open the event with his welcome address. Please, Mr. Dean.
Thank you, Professor. Thank you, Professor Arvanitakis. This is hello, everybody. Welcome to Thessaloniki. Welcome to the Aristotle University of Thessaloniki, Mr. Gevelekos and his team, very carefully selected, and this wise panel. Today, the organizers, namely the Aristotle University of Thessaloniki, the Faculty of Law, and the Faculty of Law and Social Justice, Liverpool University, jointly with Sakulas Publications, whom we thank a lot for this joint organization, as well as the European Court of Human Rights Law Review. My name is Glavinis. I'm the Dean of the Faculty of Law of Thessaloniki. And in addition to welcoming everybody and wishing very productive exchange of views in these long-lasting, as a matter of fact, issue, which is the accession of the European Union and the European legal order to the Convention of Fundamental Rights and Freedoms, and the acceptance of the jurisdiction of the European Court of Human Rights for possible violations by EU organs and the EU of the said agreement, the said convention. I would like to share with you some thoughts about this. I think we lost momentum. And we are now in a situation worldwide where definitively human rights protection is not number one issue. And the question is, who missed the European Convention in the EU? And who needs actually EU's accession to the European Convention? Is this a bureaucratic issue on which we can debate forever, as a matter of fact? Or somebody needs this? Therefore, there is a value added for the protection of human rights at European level. This is something which, for the time being, is contained in a bureaucratic and framework. And I don't know really, especially today in these circumstances, whether somebody really desperately needs this in order to advance the process of accession. Certainly, you will describe to us the different hurdles which are of legal nature and practical nature. But yet, I think that we should consider that that I don't believe that this is a real priority now. Therefore, I think that we need to revive somehow the necessity of European Union's accession to the Convention. And what will be the added value for the protection of EU corporations and citizens. With these thoughts, I would like again to welcome you in Thessaloniki, dear Vasilis Gevelekos. Thank you for co-organizing this. And I will follow with great interest your lectures. Thank you so much and welcome again.
Distinguished colleagues and guests, in my capacity as professor at the Faculty of Law of the Aristotle University of Thessaloniki, the host institution of today's workshop, and the editor-in-chief of the Lexen Forum Legal Review, which, in cooperation with the European Community on European Convention on Human Rights Law Review, is co-organizing this event, I am delighted to welcome all esteemed speakers and participants to our university, whether attending in person or online. In its 5-year publishing history, Lexen Forum has co-organized 18 conferences, including today's event. This, however, is the first to be held in hybrid format. We are truly honored to welcome you to Thessaloniki, nearly all of today's contributors, esteemed scholars from both Greece and abroad, whose presence greatly enhances the quality and significance of this event. The successful realization of such a complex endeavor would not have been possible without the joint efforts of our 2 law reviews, and in particular, the dedicated commitment of Professor Vasilis Gevelekos of the University of Liverpool, member and former Vice Chair of the UN Human Rights Council Advisory Committee, and co-editor-in-chief of the European Convention on Human Rights Law Review, as well as the generous support of the law faculties of both our universities. This collaborative initiative has brought to our city distinguished legal experts from the Council of Europe, individuals who were directly involved in the negotiation concerning the European Union's accession to the European Convention on Human Rights, as well as eminent professors from leading European universities, recognized as foremost authorities in the field under discussion today. The presence of these distinguished colleagues, alongside esteemed faculty members from our own law school, constitutes a significant honor for our academic community and underscores the importance of the issues we are addressing. The question of the European Union's accession to the European Convention on Human Rights is neither new nor unfamiliar to those working in the fields of the European law and human rights. Article 6, paragraph 2 of the Treaty of the European Union explicitly maintains the Union's accession to the Convention, albeit subject to the conditions set out in Protocol number 8 of the treaty, which requires that the unique characteristics of the Union and its legal order be safeguarded. The accession process faced a major setback with the issuance of Opinion 2 of 2013 by the Court of Justice of the European Union, delivered during the presidency of Professor Vasilios Kouris, former Dean of our Law Faculty and long-serving President of the Court of Justice of the European Union. In Opinion 213, the Court found the Draft Accession Agreement incompatible with EU law, raising concerns relating inter alia to the autonomy of EU legal order. Since then, however, significant developments have taken place. A new round of negotiation was concluded in 2023, resulting in the revised Draft Accession Agreement that brings the prospect of accession closer than ever. From its part, the Court of Justice of the European Union, in its KSKD decision of September 2024, extended its jurisdiction to cover aspects of common foreign and security policy, an area that was excluded from the 2023 Draft Accession Agreement with the intention of being addressed internally within the EU order. These developments have already been subject of scholarly discussion. With this in mind, we choose not to confine today's conference to the long-standing debate over whether accession is feasible and under what conditions. Instead, in line with the specific focus of the Lexen Forum Law Review, we have shifted our attention beyond this question towards the procedural issues that will be arised post-accession, particularly concerning the participation of the European Union and its member states before the European Court of Human Rights during proceedings, but also after a judgment has been delivered. In this respect, we trust that today's event represents a novel initiative to identify and examine these procedural challenges and opportunities, which will be thoroughly addressed by our distinguished speakers. From this position, I would like to begin by warmly thanking my colleague Vasilios Zevelekos, whose inspiration led to the organization of this hybrid event. He has guided us through the key human rights issues surrounding accession and facilitated contact with the distinguished colleagues who honor us with their presence today. I would also wish to extend special thanks to Professor Vasilis Pergandis of our Faculty of Law, who, in addition to contributing as a speaker, has played a key role as co-organizer, successfully overseeing the technical coordination of today's event. We are also deeply grateful to the Law Faculty of Aristotle University of Thessaloniki and the University of Liverpool School of Law, as well as to the Research Committee of the Aristotle University. Thanks to the financial support of these institutions, our speakers have been able to attend in person. Our sincere thanks also go to Sakula's Publication for their unwavering technical and editorial support in all our initiatives. And of course, we extend our heartfelt thanks to all of today's speakers and discussants for sharing their academic expertise and valuable insights and for being here with us. In the order of their presentations, Mr. Christos Giacoumopoulos, who until very recently was the Council of Europe's General Director of Human Rights and Rule of Law, Professor Christine Bicknell from the University of ECHR, with research focus on the international and European human rights law. Mrs. Zoe Brianson Cross, from the Office of the President of the European Court of Human Rights, who brings extensive experience in the execution of the judgments of the European Court of Human Rights, having previously worked with the Council of Europe's Committee of Ministers. Professor Liz Glass from Radboud University, Nijmegen, Professor of International and European Law, Professor Vasilis Pergadis from our law school, Mr. David Milner, Head of the Human Rights Intergovernmental Cooperation Division and Secretary of the Steering Committee for Human Rights within the Council of Europe, that negotiate the 2023 Draft Accession Agreement, and last but not least, our very own Professor of EU Law, Iosif Ktenidis. Lastly, I would like to express my gratitude to all of you for your participation and attention. Before I give the floor to the chair of the panel, Professor Vasilis Zevelekos, I would like to inform you that for those attending the event online, they can ask questions to the presenters only through the Q&A application until the end of the presentation of the speakers and the discussants, with the request to mention the name of the presenter to whom the question is addressed. And now I invite the chair of today's event, Professor Vasilis Zevelekos, to take the floor.
Well, thank you very much, Paris. I'm always very happy to return to this university. And I would like to, I have to thank quite a few people today, but I will start with the Dean, Professor Glavinis. Thank you for your hospitality and warm support. Without you, this event wouldn't have been possible. I would like to also, from my side, thank my two co-organizers, Professor Arvantakis and Professor Pergandis, or Paris and Vasilis, to make it a bit more informal. Again, without you, this would have not been possible. I would like to thank the participants, both the ones who are present in the room and the ones that are attending online, particularly the ones that are in this room. I know that you willingly chose to be here today. 3 dots. Speaking on behalf of the ECtHR review, I'm the co-editor-in-chief of this law journal, and we are co-organizing this with Lexen Forum, the journal run by Paris. I must say that we are very pleased to join our forces with Lexen Forum, which, from at least this is my unbiased point of view, it is an excellent journal, really international, extrovert, and with great potential. Thanks to your efforts, dear Paris. Then I would also like to thank the speakers, particularly those that traveled today to be with us. Unfortunately, the weather is not going to be very good as of tomorrow, but yeah, it's your fault. You brought the bad weather. We have this excellent line of speakers, and we will get organized in the following way. We will have 3 presentations, and I'll explain in a while. Why. I will take then some questions, and then we have the 2 discussants who will again discuss the papers and give their own perspective. And again, if time permitting, we can have another round of Q&A. We were expecting, so Mr. Yakomopoulos, who delivered the opening remarks, the opening talk in a while, was not expected to be with us, so he would do it online due to conflicting commitments. But we were expecting Miss Zoe Brianson Cross to be with us. The story is the following. She was on her way here, and then there was a problem with the plane, and they had to return to Frankfurt. Apparently, it was quite serious because ambulances and fire brigade, etc., were involved. Everyone is safe. And as we speak, she's flying, she's coming, but most probably she will come late. So I have some instructions here to delay as much, which means that we'll keep speaking for the next hour or so that we finish at about 10 p.m. tonight, so that we give you the opportunity to make your presentation. And of course, the doors will be locked and no one will be allowed to leave the room. But the good thing is Zoe is good, and yeah, if she cannot make it today, she will make it tomorrow. We have a closed session tomorrow, like a roundtable discussion. But of course, if you willingly want to join us, by all means, feel free to do so. Now, just a few more words from my side, and then I promise I will shut up for the rest of the meeting. A few words on the rationale behind the today's focus. So you all know more or less, and then we will also have the overview given by our first speaker about the EU accession to European Convention of Human Rights. It's a very long saga. We have a new draft agreement. And this new draft agreement, which is pending, will be reviewed soon by the Court of Justice of the European Union, hopefully, we hope so, has been already discussed in academic writings and scholarship. There are at least 2 special journal issues that came out on this topic. One, I think we both wrote in European papers. And then my journal, the journal we are running, I should also mention the name of my co-editor-in-chief, Konstantin Zechtiarov, for those of you who are experts in the ECHR, he's very well known. We just published another special issue that hosts, among other papers, a paper by David and Christos. So Mr. Yakoumopoulos and Mr. Milner, or Christos and David. But what has not been yet, so these special issues and the literature that already exists discusses the bigger picture, the structure of this draft agreement, how it is dealing with the participation of the EU, the chances of it being successful when it will be reviewed by the Court of Justice of the European Union, and so on and so forth. What has not yet been discussed, and this is what we want to do today, is the more procedural dimension. And this is why we're also joining forces with Lexan Forum, which specializes on procedure. So hopefully at some point, we'll have the EU becoming a party to the European Convention of Human Rights. And then if when the so-called correspondent mechanism applies, you will have the EU and the member states being before the European Court of Human Rights as one entity. This is the so-called joint responsibility. However, this to me looks quite artificial. First of all, not even states can always speak with one voice. I'm coming from the perspective of public international law. We say the state is one single entity, state voluntarism, 19th century theory, etc. But states, if you think of it, they do not always speak with one voice, in particular democracies. You have courts that may disagree with the government. You have a change of government and the policy changes. So this is already quite complex when you have a state. But when you have the EU, which is something in between an international organization and a quasi-federation, and it wants to appear before the European Court of Human Rights jointly with the member states, as if they are one single entity, I don't know practically how well, or I think it can work in the end, but it will be more difficult maybe than what we anticipate. Therefore, this is the focus, proceedings, and the EU and the member states speaking presumably with one voice. And we'll be discussing aspects such as friendly settlements. We'll be discussing the question of the burden of proof and the allocation of the burden of proof between the respondent, which is the EU and the member states, and the applicant. But the respondent, again, is not. It's the EU and the member states. We will be discussing, or if Zoe makes it here, but I think David can also cover this, we'll be discussing the question of the execution. Once a judgment has been delivered, it goes to the Committee of Ministers. On paper, both the EU and the member states are jointly responsible. This is the whole purpose of the accession agreement, that the European Court of Human Rights does not interfere with the domestic issues of the EU and does not allocate competencies, responsibilities, etc. But when we reach the point of the Committee of Ministers, the Committee of Ministers will need to say, you as a state, you need to change your practice. You as the EU, you will need to change your legislation. And in this case, we have already allocation of responsibility and joint responsibility. Goodbye. It has disappeared. So behind what we will be discussing today, for me, the big question is to what extent joint responsibility is just a bubble, just an artificial concept that will not apply in reality. I will stop here, and without further ado, I would like to invite Mr. Christos Giacomopoulou. It is obviously a great honor for us to have Mr. Giacomopoulou. I don't think he needs any introductions. He's the Council of Europe. He has been with the Council of Europe for many decades, and he was, until very recently, the General Director on human rights and rule of law, etc. So he's someone who had the general oversight over these negotiations. I know that he has been following this very closely. David, who is sitting over there, or you prefer Mr. Milner? Yeah, David, who is sitting over there. He's the person that actually led the negotiations on behalf of the Council of Europe and conducted the negotiations. So we have insights that are very useful. And I'm very much thankful to Mr. Giacomopoulou for accepting, in spite of his very heavy schedule, to be with us today and to give us his perspective. So, dear Christos, the floor is yours.
Dear Vasilis, dear panelists, dear participants, thank you very much. First of all, I would like to apologize because I'm not with you in Thessaloniki, and it's also with great regret because, as some might know, the University of Thessaloniki is my alma mater. So I would be very happy to be with you this time. I will try to make not a very long, actually, but despite the general wish to have Zoe with us very late today, I will try to make it short. And I will just make a general presentation of how the issue has developed and why we are now at a crucial moment of the whole process. Because the issue of the accession of the European Union to the ECHR is not at all a new issue, as you all know. It is a long-standing political priority of the Council of Europe, and it is also, since the Lisbon Treaty, also a legal obligation of the EU. But the whole discussion goes actually back to the late 70s, when we had, following the Solani judgment of the German Constitutional Court, the European Commission, back in 1979 already, for the first time proposed that the European Community accedes to the ECHR. And in 1994, the Council asked the Luxembourg Court to whether the accession of the European Community to the ECHR would be compatible with the treaty establishing the community at that time. And indeed, the Luxembourg Court, in an opinion that it gave at that time, considered that Article 6 of the Treaty of the European Union did not allow the community to accede. Actually, it ruled that the institutional implications of the accession of the European Community to the ECHR would go beyond the scope of the provisions of the treaty that might have provided a legal basis for accession. Antonio La Pergola was at that time the Advocate General, and he made this proposal, this position, and actually the court followed the position of Advocate General La Pergola. So this problem of the legal basis was in principle resolved by the Lisbon Treaty. in Article 6.2. So the competence is established, and there is also, at least in my view, an obligation and a rule of law issue for the EU to accede to the ECHR. Now, how did this materialize? In 2013, we had a package of draft accession agreements, which would allow the European Union to accede to the European Convention of Human Rights that were adopted by the Steering Committee of Human Rights of the Council of Europe following negotiations between the 47 member states and the EU. The Committee of Ministers approved this the draft, actually by taking note of. But in the meantime, the European Commission had submitted the draft accession instruments to the Luxembourg Court, and the Court of Justice found in December 2014, in an opinion, this famous opinion 213, it concluded, I think surprisingly to some extent, that the agreement, as it was drafted, was not compatible with Article 6.2 of the treaty or with Protocol number 8. This actually, I think it came as a surprise, at least for the Council of Europe, but for sure also for the Commission, the EU Commission, and also for the member states, the huge majority of which were in favor of the accession and had pleaded before the Luxembourg Court for the compatibility of the accession agreements. Nonetheless, this has the opinion, of course, has stopped the whole process, and a number of issues that were raised by in the opinion have been worked seriously by the Commission and by the Council of Europe. And in 2019, Jean-Claude Juncker, then President of the European Commission, informed the Secretary General of the Council of Europe that we could now resume negotiations on the basis, and indeed there was another, the CEDH, the Steering Committee of Human Rights, continued working on the accession agreement. David, who was the secretary of this negotiating group and has followed, and of course was actually quite instrumental in obtaining the results, the very good results, by the way, which satisfy both the Council of Europe and the Commission. The group examined the issues that were raised in the opinion 213 of the Court of Justice of the European Union in 4 baskets. The first one, which is the one on which I believe most of the discussions of this meeting will refer to, was the EU-specific mechanisms of procedure before the European Court of Human Rights, the corresponding mechanisms, etc. The second basket, which has a big political aspect, is the operation of the inter-party applications, in particular in relation to EU member states. The third point was about mutual trust. I think Vasilis Pergandis has written a lot about that. And the fourth one was about the common foreign and security policy. The result, which was communicated to the CDH, in the CDH, in the Steering Committee's report to the Committee of Ministers, is actually a very encouraging result, because there was a unanimous agreement on solutions on basket 1 and 3. And the group considered that the agreement satisfies the general principle on which it had agreed to work, namely to preserve the equal rights of all individuals under the Convention. This is the first thing. To safeguard the rights of applicants in the Convention proceedings and the equality of all high contracting parties, and also to safeguard the control mechanism of the Convention, to preserve the control mechanism of the Convention taking into account as far as possible the EU particularities and trying to apply to the EU the same procedures as in other high contracting parties, as far as possible. And we will see if you have seen the result that actually the EU is extremely privileged in this agreement. Now, as regards the basket 4, the common foreign and security policy, the EU informed the group that this was an issue to be resolved internally in the EU, and that there was no need for the group, negotiating group, to address this issue at the time. And perhaps it is not. Actually, the main issue is whether the Luxembourg court has the capacity or is competent or to look at issues of CFSP, or it is completely excluded. And I believe that the recent cases of KS and KD, to which already Professor Ventex has referred, more or less resolve the issue because it is quite clear, I think, from this judgment of the Grand Chamber, that the basic principles of the EU legal order, and in particular the respect of rule of law and fundamental rights, apply also to the CFSP, and therefore both the EU and member states authorities should be subject to judicial review. Consequently, the Court of Justice of the European Union has jurisdiction to rule on acts or omissions that are not directly linked to the political strategic choices made by the EU, but to human rights aspects of these policies. And this, the issue had to do with ineffective investigation into deaths, ineffective investigation by EULEX, actually, in Kosovo, into deaths of family members of the applicants. So perhaps it is the issue of the CFSP is also resolved, but this is, of course, under discussion. And I believe, perhaps David could correct me if I'm wrong on that, that there is an obligation of the Commission to inform the Committee of Ministers about how these things are dealt with now, whether the issue has been resolved in within the EU, but this has not yet been the case. Now, on the basis of this, and I would not like to go very deeply into the details of what we will be discussing, particularly the procedural aspects this is referred to. Let me say the following. There are problems in the accession. And as my former Director General of the Council of Europe used to say, of course there are problems in the accession. And if you want, I can find every day a serious problem, not a fake one, a serious and a real problem about the accession, if you want to avoid the accession. So, but you may also take a more positive approach. The agreement will not and cannot actually solve all the possible problems, and we must also trust the courts, their competencies and their powers to solve problems both in Luxembourg and in Strasbourg. And this is why I believe that it is extremely important that this discussion starts already about the possible problems, and that the doctrine and the meetings like this one also can look into the various issues that will arise and already provide for some direction, solutions, which could inspire the courts. Let me just say that the accession, as I see it at least today, is a huge advantage for the European Union on the basis of this agreement, much more for the European Union than for the Council of Europe, actually. Why? First of all, because the EU, as a supranational entity with legislative competencies, with powers affecting millions of European citizens, and not only European citizens, but also plenty of other people too, it is not possible for the EU to escape the collective guarantee of human rights, which is the main human rights achievement after the World War II, as established by the ECHR. I mean, actually, yes, one may say, is the Charter of Fundamental Rights sufficient? It is sufficient for the protection of human rights. It is not sufficient for the collective guarantee. It is sufficient in the same way as any national constitution is sufficient for the protection of human rights. But the history of the ECHR has shown very clearly that this may not be the case quite often. So it is important that the European Union has its own list of individual rights that go beyond the three basic freedoms, liberties of the EU. But this is not part of the system that was created in Europe after the World War II, where you have a guarantee of human rights for which states and entities, including the EU, should be collectively responsible. And this is an achievement that the EU cannot ignore and cannot be the only one which is outside this system. Being subject to the European Convention of Human Rights and to the European Court of Human Rights is actually a signal of democratic maturity. It is a signal of trust to the institutions of the state, the institutions of the entity which is bound by the European Convention of Human Rights. And escaping this process means that the institutions are fragile and that the trust to the democratic processes is fragile too. I don't think that it is in the interest of the European Union, in particular today, to give the impression that it is unable to uphold human rights, at least in the same or equivalent manner as do its own member states. So this is, I believe, a political reason for the accession. A rule of law reason is, of course, Article 6.2 of the treaty, which clearly says the Union shall accede. It does not say may accede or could accede or whatever. It is an order, I believe. It creates an obligation to accede, but of course it subjects this accession to the safeguarding the Union's law. This means that there should be a clear indication of whether the Union law does not allow, finally, to have this accession. And I will come back to that. Now, one other reason for which I believe the present draft agreement is extremely important for the EU is that it is extremely privileged. The EU has an extremely preferential treatment in the draft agreement. The correspondent mechanism, the possibility to preempt cases, the previous involvement, and all these things are elements which are surprisingly were accepted by non-EU member states. And I'm not sure that it will, any negotiation that could resume would go further than that. I believe, again, that it might even be more difficult. There is, of course, also a human rights reason for the accession. From the human rights perspective, I think that it is neither advisable nor possible to deprive the European citizens from the right to petition to the European Court of Human Rights against, to complain about any act in any field of their lives that is has been affected by EU policies. Since the EU competencies are continue to extend. Actually, it will be a deprivation of a fundamental right under the European Convention of Human Rights, which is an instrument, constitutional instrument of European law. Now, before I conclude, I would like just to signal the following. Now, we've been discussing this issue of the accession for more than 40 years now. In the Council of Europe, the European Court of Human Rights, the Luxembourg Court, member state judiciaries, academia, the Commission, the Council, everyone has been discussing this. And during these discussions and in the expectation of this accession, a number of theories and case law doctrines have been developed, in particular by the national judiciaries, but also by the European Court of Human Rights, concerning the scope of control that it can exercise over EU acts or acts of the EU being implemented by national institutions. I think this is the Bosphorus approach. Now, if this attempt fails, if this accession process does not give the expected results, again, the conclusion can only be, in my view at least, that the EU accession will not take place, or at least it will not take place without a fundamental change in the EU treaties, and I believe that nobody would like to change the EU treaties now. So if this is something that is perceived as a key, that there will be no accession, then this will means that the court, and in particular the Strasbourg court, will have to reconsider, revise the basis of its Bosphorus approach, and take into account the lack of any prospect of accession, and redefine its competencies in the facilities field. And decide, actually, the court will have to decide how to deal with member states and member states' bodies and member states' institutions when they apply EU law or act as EU bodies. And I can only guess, actually, Vasilis Pergandis, in a paper that he has presented some time ago, has already indicated that there are some diverging positions in the case law of the court in Strasbourg on the implementation of the Bosphorus doctrine. And I can only guess that in the future, probably, this change in the approach will continue. It will not be immediate, it will not be sudden, but probably progressive in various stages based on the Strasbourg Court's case law. And this, unfortunately, will necessarily create instability and to some extent confusion, and it will be detrimental to the legal security in Europe. It will also probably create problems within member states, because they will have to take into account two possibly conflicting different legal orders, in particular in respect of fundamental rights. You may, in this respect, I would like to refer to a paper which was made by Johan Callevet, Professor Johan Callevet, who is also the Deputy Grand Chamber Registrar, who has referred to the tendency of the Luxembourg Court to consider the ECHR as an optional element in deciding a case. Situation of the ECHR in union law, which is characterized by the fact that it is taken into account more often as an option rather than as a guarantee. And this is contrary both to the treaties of the EU and, of course, to the ECHR, which also binds each and every member state of the EU. So I think that this will create many problems, and in particular, it will also expose individuals to this uncertainty. It will also expose the European Union to this indirect European Court of Human Rights control without the benefit of all these privileges that it has under the agreements, without prior involvement, without the correspondent mechanisms and all these aspects that are already in the draft agreement. So I believe that this is absolutely essential, crucial, that the EU takes now rapid steps proceed with the next steps, inform the Committee of Ministers that about the CFSP and how it has managed to resolve this issue internally within the EU, and then go for another opinion of the Luxembourg Court on the basis of the new agreement. I would like to finish by saying that it is true, it is absolutely true that the reasons for which the EU had initiated this process of ratification of accession to the ECHR, which was the lack of a catalogue of fundamental rights in the EU legal order, is no longer valid, because now we have the Charter of Fundamental Rights, which has been given legal force. So it is essential that this part has been covered, but there are many other aspects, in particular the ones I have referred to, which make the Strasbourg's the accession of the EU to the ECHR a very important step in the interest of the EU. So the revised draft instruments for the accession of the EU are offer the EU the opportunity to be subject to this external judicial supervision by the European Court of Human Rights in a way that takes all specificities of the EU duly into account. So I hope that this discussion that we will have today and tomorrow will contribute to the understanding of the mechanism and how it will work in the future, and hopefully not in the very distant future. Thank you very much for your attention.
Thank you very much, Christos. Very comprehensive and clear as always, and for giving us also the compelling reasons as to why the EU shall accede to the European Convention of Human Rights. I know that there is a technical issue, you having some difficulties in hearing us. If at any point you would like to just leave, please feel free to do so. Otherwise, I will leave my phone open, and hopefully you will be able to hear us. So now we're moving with the first substantive talk, focusing on a very complex issue, which is burden of proof. It is already very inconsistent, I would say, and complex in cases that do not involve the EU. And now with the EU, we are adding a layer of complexity. I know that this presentation involves some speculation as to what will happen in the future, which makes it more difficult. And I would like to invite Christine to take the floor, and thank her for being here. In the meantime, those of you who practice law, if you've ever brought the case before the European Court of Human Rights, you will appreciate how difficult in some circumstances it is to provide evidence. Okay, you can think of scenarios where the applicant has no means to prove the allegations they make. Okay. Thank you, Christine.
Thank you. Thank you for having me here. I have tried to strictly time this to 15 minutes.
Sorry.
Beg your pardon. Hang on. Thank you very much. So hopefully my slides work then. I am going to try and stick strictly to the time, but okay, I'll do my best. Okay, I've been asked to speak to you about the burden of proof in cases involving EU law post-accession. I'll explain a bit more about this point about EU law. Originally, I was actually asked to look specifically under the co-respondent mechanism, but actually this has broadened the scope of what I can talk to you about today. Now, I liken this entire project with a three-dimensional puzzle. This is an extremely complicated, complex area, this accession agreement, and hats off to the negotiators because it's really difficult. There's what's had to happen post the opinion 213, which in fairness, it was like a bit of one of those puzzles that you would look at, and that opinion happened and it all fell apart. So they've had to rebuild. They've had to accommodate certain core rigid features. The autonomy of the EU legal system is one of them that I'll talk to you about today when I'm looking at this issue of burden of proof, and mutual trust and mutual recognition is another dimension that I'll talk to you about. I'm going to have to assume certain levels of knowledge about those points though. They've also had to look again at the co-respondent mechanism, and this is where we have joint responsibility. Please forgive the continued relevance, that actually was supposed to be the next bit down, so ignore my typo in there. But there is currently something called for the presumption of equivalent protection that occurs, and there is. I'm conscious that Professor Tsevelikos, together with Franklin, has published on this and its continued relevance post-accession. I'm not going to talk very much about that, but there are question marks over all of this and what it would look like post-accession. So obviously these bits on the side, but what I'm going to talk to you about is specifically the burden of proof, because it places a spotlight on some of these issues. And I think it enables us to tease out some of those tensions that occur within this agreement, and that there's a lot of different, very complex relationships within this, between two international organisations, their respective courts, also the member states themselves, their relationship with the respective institutions, but also, and the conventions, but also between each other. And so these are all quite important issues to be aware of. I'm going to explain the reference to EU law then. I'm going to explain burden of proof very briefly, and I'm going to demonstrate with reference to three specific types of case or proceedings that might occur, what the burden of proof and thinking about the burden of proof post-accession actually might tell us about this further. So I'll leave a summary at the end, but I won't read you those points. There won't be time. So essentially, it's an issue of serving two masters. All EU states are also states party to the ECHR. So there are instances where the EU member state might have to follow EU law, but in doing so, there may be an issue with its compliance with the ECHR. And this is why we have this Bosphorus presumption currently pre-accession, because a case can't be brought against the EU directly. Now, types of cases which might arise. I've nicked this from someone called Lawson, by the way, who in his own writing has sort of set out these different types, but I've used it as a framework in my discussion. So there might be complaints against acts, which are, of course, underpinned by law of the EU and its institutions. Complaints about the implementation of EU law, which might be, obviously, the member states implementing it, but the EU post-accession obviously would be the originator or the origin of that law, and complaints about cooperation between EU member states, because there's a requirement under certain EU laws of mutual trust and mutual recognition between each other. So they place trust in each other that they comply with fundamental rights. I'm going to use that as a framework, but I'll talk about burden of proof. Now, I've just used a quote here, but it really does speak to the problem with burden of proof. The evidentiary system in total in the European Court of Human Rights is complicated, often confusing, surprisingly technical, constantly evolving, commonly inconsistent, and repeatedly stacked against the applicant. The applicant, of course, being the person that's alleging that their human rights have been violated. And this is another level of complexity to actually discussing burden of proof in the context of an accession agreement that is in draft only. And so there's a lot of this can be speculative. But burden of proof, it's about who must prove something and what they must prove. That's burden of proof. But within that evidentiary dimension, we're also talking about to what degree of certainty they need to prove something. So that's your standard of proof. And what evidence is acceptable to the court. Well, I think it's also advisable to sort of think in terms of what proof means. So I work backwards, actually. I've written this as a paper as well, but I work backwards from the standard of proof to sort of think about burden of proof or proof in a broader dimension. I would first add, though, that it has been questioned whether the European Court of Human Rights is an inquisitorial court or an adversarial court. Adversarial would place that burden very squarely on the applicant. But actually, when you look at what how the Strasbourg court works, it draws from lots of different sources if something needs to be proven. So, but I think it's also helpful to think in terms of of proof as capable, and whether you want to talk about standard of proof or burden of proof, it's capable of a narrow definitional conceptualization where we're talking only and specifically about proof of fact. It's capable also, and this is relevant to particularly to qualified rights, for instance, it's capable also of a wider conception, which would be persuasion, if you like, that a particular restriction on somebody's right, for instance, maybe your freedom of expression has been restricted, that is disproportionate. It's more persuasive, it's more argument-led. And so I think in the round, we'd need to accept a wider conception here as applicable, but it's just worth pointing that out. Incidentally, all the examples I end up talking to you about fact-driven, but the facts are usually established beforehand because of the nature of the European Court of Human Rights. Usually because of subsidiarity and because of the particular requirements to bring a case in the first place, they've been settled. And the court generally trusts that the national courts have kind of got that right. The burden is usually on the applicant, but the applicant has to prove their case. And that's not necessarily about proving just individual facts and every individual fact. In certain circumstances, and I've raised this, it is relevant, the burden can be reversed. That's if the respondent state is being uncooperative. It's usually in something like disappearances, and the information that might be within the hands of the respondent state, but the applicant doesn't have access to it, the court doesn't, and so the burden is shifted onto the respondent state. Presumption is made against the state. Now, going into sort of a more, let's look at actually what this would look like in practice in the different types of cases that would occur. First of all, we've got complaints about acts and law of the EU and its institutions. That may or it may not include the co-respondent mechanism, so a member state might also be a respondent in that case. They might not be. Now, but one thing I want to flag is that because I've been allowed to talk about law in a wider sense and not just co-respondent mechanism, Frontex operations may very much come into the firing line here. So this is the EU border agency. I think it was last year, the EU Committee on Civil Liberties, Justice and Home Affairs looked at a proposed status agreement on operational activities with Senegal. And whereas they flagged problems, the risk that Frontex might directly be involved in refoulement, so returning a person where there's a real risk to their personal safety, which can include torture and inhuman degrading treatment or punishment, might include the risk to their life. There was a risk of that direct involvement. They made recommendations to Parliament, but that they would raise this with the Commission. That wasn't taken forward. So the EU is not always very rights-oriented as its start point. Something like that, especially at the point that you would get operations happening, would then come up before the European Court of human rights. It would have to. Now, in bringing proof back into this, though, proof is context dependent. In the literature, it's a very recent paper, somebody called Baranowska has actually suggested that you should treat pushback operations in the same way as you treat disappearances. A presumption is made against the state. And I think it's a very powerful argument to make. But this would arguably create tensions between those two courts. It's kind of inescapable that would be the case. And we have to recognise the European Court of Human Rights, its bottom line is it's protecting rights. It has these particular standards to protect, and it does so. So there's potentially a tension. The way that would be, I would suggest it should be resolved, or could be resolved, is actually the EU, knowing this is coming down the line, knowing that the accession is coming down the line, have a really rigorous review of its internal review of its law to look for ECHR compliance, because something like that has already been flagged by its own internal people and not been picked up. So if I may, because of time, I'll move on to my second type of proceedings, if you like, complaints about EU law and its implementation. Now, the EU-Turkey statement and action plan I've flagged here. It's about outsourcing refugee protection to Turkey. Both those European Union courts, put it on the slide, they declined to look at the agreement's compliance with fundamental rights. They did so because they actually said, well, this is an agreement that was with the member states, not the EU institutions. And actually, that speaks to one of the issues I'm flagging in a moment about sort of that good faith and cordial relations between the member states and the European Union. But if we're thinking about, and so the way you address that is exactly the same suggestion that I made previously, so I won't repeat it. But this is a context in which the co-respondent mechanism may be invoked. And this is where actually we've heard already about this idea of joint responsibility. Now, if there is where the co-respondent mechanism is in operation, if there is a breach of the ECHR, the outcome is that it's joint responsibility, which goes to the member state and the European Union. Well, actually, if we bring proof into this, the applicant is the person that starts this off of pulling this apart, because the applicant has to state their case. And the applicant has to say, well, okay, this law is faulty, or the implementation is faulty, or they're both faulty, but you're starting to see attribution of cause. And so it's sort of, and I've suggested it belies joint responsibility as a legal fiction. It's so much a legal fiction. It's something that applies only at the point of the outcome. Yes, there's been a violation, you're jointly responsible. But in reality, as soon as you start looking at proof, the state the case, and then you have to look into the detail of what's gone wrong, actually, you've pulled that apart. There's different causes within this, and that that may be problematic from an autonomy perspective, the EU autonomy perspective. It also means potentially where rebuttal comes into play, there may be tension not only between the two courts but also between EU member states and the EU itself. Now, the third point, trashing my timing here, but only slightly. Complaints relating to member state cooperation. So under mutual trust and mutual recognition are two quite key principles of EU law to enable smooth and harmonious running of certain, I suppose, procedures. European arrest warrant and Dublin III regulation are the two that I am pulling out here as examples. But Dublin III, I don't want to labour this slide too much, but it has been flagged that this is unevenly applied by member states themselves, which causes a problem. And so we have this question, potentially mutual trust might mean the applicant has to prove a state to which they might be sent or returned, they transited through already, would be unsafe. The Council of Europe has already said it has a standard on this, that no, that should not be an elevated burden of proof for the applicant in that particular context, which then starts to actually build into this point about different standards from different courts and not full confluence between them. Also, I can envisage perhaps maybe a pilot judgment, maybe in this, maybe even in the European arrest warrant context, where instead of, I think the European arrest warrant is probably the better example, but where the European Court of Human Rights might say, well, actually, you can't send people to this state, you know, because there's particular problems within our prison system, and so that we have to consider prisons to be unsafe. There are potential tensions. The European arrest warrant, then, just quickly, a state would ask for a person, generally a criminal suspect, to be sent back to them. So it's the issuing state requests the person to be sent to them. The executing state sends them. Now, this is important because this issue, not in this context, the Avotins case, but the Avotins case is about the fact that mutual trust should not be automatically or mechanically applied, and that has been relegated to the explanatory report, is no longer in the main document. And it has been questioned in the literature as well that there's confluence between the two courts, but it's that confluence which underpins the approach that's been taken in the draft agreement. I would suggest that even within, so that particular point suggests, and in the literature it is suggested that there are certain areas where mutual trust is applied almost automatically, and other areas where there's a bit more leeway for states to question the rights compliance of another state. So Article 3 ECHR is one where there's more scope, more leeway for the executing state to question. But I would suggest that even with within the European arrest warrant scheme, there isn't full alignment between the two courts. I think the EU has more of a drive to the minimum standard it can get to, and I think the European Court of Human Rights has a higher standard. So where does that leave us? So mutual trust carries heavy presumptions, and a presumption is the antithesis of proof. It's the opposite. Equivalence is vague if the Bosphorus presumption were to be continued, and these standards and approaches between the two courts still appear to be different. I've trashed my timing, but there's an overview of all those key points that I pulled out, and it's 17.5 minutes. Thank you.
So thank you so much for this presentation, and particularly for the classification and the different types of scenarios of cases, which are all very realistic. And I think these are cases we'll see coming before the court if particularly the correspondent mechanism applies. Now I will pass the floor to Liz, and we move to the question of unilateral declarations and friendly settlements by the EU or the member states in cases against them. Thank you so much, Lee.
Okay, well, thank you. So, today I will discuss the role that friendly settlements and unilateral declarations may play in cases involving EU law after accession. And this is a matter that has hardly received any attention at all. So I'm very grateful for the invitation to come here today and speak about it. And I also very much enjoyed writing about it. So thank you very much for this wonderful workshop. So what I'll do in this presentation is I will first give a very short introduction to friendly settlements and unilateral declarations. I assume most people know what they are about, but I think we have about 100 persons listening, like here and also online. So I'll give a short explanation, and I will then deal with, well, how can these two procedures be used in the three scenarios in which the EU is a party or is involved in ECHR proceedings after accession, and that's if the EU is a respondent, so on its own. When the co-respondent mechanism applies, well, we've heard about the co-respondent mechanism already, and when the CJEU is involved in the ECHR proceedings by means of the prior involvement procedure. So what are friendly settlements and unilateral declarations? Well, they're basically a way to resolve a case, usually before the European Court of Human Rights has issued a judgment. And they've become largely a work management tool. So they're a relatively fast and budget-friendly method of concluding a case. And the court has facilitated adopting friendly settlements and unilateral declarations by introducing a non-contentious phase of 12 weeks. So before the state and the applicant start exchanging their observations, there's a non-contentious phase meant to conclude a friendly settlement. And the registry facilitates this by actually making proposals, which the parties only have to sign when a case can be solved based on well-established case law. So looking at friendly settlements specifically, they're an agreement between the parties. The negotiations leading to this document are confidential, and they usually include an ex gratia payment, meaning that the state doesn't acknowledge responsibility or doesn't acknowledge that there was a violation. It's a payment basically to make the case stop. And friendly settlements, the execution of these documents is supervised by the Committee of Ministers. Unilateral declarations, well, it's in the name, right? They're unilateral, so they're a declaration by the state. And therefore the applicant's approval isn't required for adopting this document. And most unilateral declarations are rather short. They include an acknowledgement of the violation and also compensation. So the court checks whether these two requirements have been fulfilled, but it can also take into consideration other factors when looking into a unilateral declaration. For example, whether the case raises issues that have already been raised in other cases. And if so, well, that's a reason perhaps to approve the document. But whereas if the issue is completely new, that may be a reason not to approve the unilateral declaration. And the execution of unilateral declarations is hardly ever supervised by the Committee of Ministers. So this is a short introduction into the two documents. Moving on to the first scenario in which, well, EU law can play a role after accession, and that is perhaps the most straightforward situation, and that is where the EU and the EU alone is a respondent party. So an applicant brings a case against the EU. Well, clearly friendly settlements and unilateral declarations can be used in this scenario, but I think the court should be careful to accept these documents, especially in the first years after accession. When the court decides whether or not to approve such a document, it looks at the human rights condition. That's what's provided for in the convention, and it's not very clear how it assesses this condition in the context of friendly settlements, because the negotiations are confidential. But still, I would argue that, well, perhaps because of this condition, the court should at least be very careful when, well, deciding whether or not to accept such a document. And that is because cases relating to the EU will be very new. They will be very rare, I think, too. And well, the court has said numerous times in its judgments that its judgments serve not only, to solve the very specific case before it, but also to develop the convention rules and to raise the convention standards. Well, if it would too easily accept unilateral declarations and friendly settlements that the EU negotiated or adopts, it will not be able to exercise this function. And it will not be able to raise the convention standards in the context of EU law. And so that applies to friendly settlements, but I would say that the same words of caution also apply to unilateral declarations, in particular because, as I explained before, one of the factors that the court takes into consideration is whether the issue that is raised is comparable to issues that the court already decided. And it's rather unlikely that that will be the case in a case brought against the EU. So if the EU were to adopt these documents nevertheless, and the ECHR would be approving them, it would of course be really important to consider beforehand, well, which EU body will draft and negotiate this document, which body will sign it, and which institutions within the EU can be bound to this document. That's difficult for in case of states parties, but it's probably even more difficult for the EU because there are so many actors involved in, for example, amending and drafting secondary legislation. And another point for the EU would be to consider, well, who's responsible for executing, for implementing such a document. And that is, of course, particularly important when it comes to a unilateral declaration, because the Committee of Ministers will not be involved in supervising the execution of that document. So it's really in the hands of the EU. It's quite a responsibility. So this is the first scenario where I mainly express some words of caution. Moving on to the second scenario, and that one has, well, been dealt with already. So the co-respondent mechanism, the mechanism whereby both the EU and a member state are a party to the case. And well, the draft explanatory report to the accession agreement, so not the accession agreement itself, but the report, notes that, as you may expect, that when the co-respondent mechanism applies, both the EU and the member state will have to agree to this document. This sounds really logical to me. And I would say that the same words of caution that I just expressed for the first scenario would apply to the second scenario as well, and that you should therefore perhaps be hesitant to use these two procedures in the first years after accession. However, I also propose that they can be used in a certain way, but this proposal requires some explanation, so please bear with me. And like Christine already also, well, pointed out, I would like to invite you to consider the consequences of having a judgment in which the EU and an EU member state are held jointly responsible. This, I think, would be very hard also to explain to the applicant. So there is a violation, but we don't know who's responsible and to what extent. It will also be very hard for the Committee of Ministers, I guess, to supervise, because you need to be able to point out who's responsible for what, if you want to know what execution measures need to be taken. And that is why I also posed a question in my paper, who should be responsible for allocating responsibility? Well, there's different options. The ECTHR is clearly not a good option. Well, for one thing, of course, the accession agreement says it should hold the EU and the member state jointly responsible. And this choice was made in response to opinion 213, the opinion that was mentioned before already, in which the Court of Justice said that when the ECTHR would decide on this question, it would risk adversely affecting the division of powers between the EU and its member states. Instead, the decision should be resolved solely in accordance with the relevant rules of EU law and also be subject to review if necessary by the CJEU itself, which has exclusive jurisdiction in such matters. So that's what the CJEU laid down very clearly in Opinion 213. Well, another body that you may want to consider is the Committee of Ministers, but I dismiss this option basically for the same reasons as the CJEU rejected the ECTHR. It would also be a non-EU institution deciding on EU matters, and I don't think that the CJEU would be very happy about that, especially taking into consideration, you know, this very critical Opinion 213. What about the two respondents? Can't they come to an agreement on who's responsible? Well, no, and that's simply because the CJEU explicitly also said in Opinion 213 that this should not happen. The fourth option is the EU Commission, and at first sight, this may be a feasible option. The Commission is known as the one that guards the EU treaties, and when it would take a decision on responsibility, this would probably also be subject to review by the CJEU under the action for annulment. So at first sight, this may be an option. However, when thinking more deeply about it, it's not actually a very good option, and also not when taking into consideration the perspective of the applicants. And this is a perspective that, according at least to some NGOs, has perhaps been forgotten a bit during the negotiations. It was really about, or to a large extent, also about appeasing the CJEU. So why would the Commission's involvement be problematic from the applicant's perspective? Well, for three reasons. First of all, the Commission will probably be the one representing the EU before the ECTHR, so would take on the role of the state agent. And it would then, yeah, you would be mixing rules that you should not mix, I think, having the same institution arguing against the violation and then also deciding on the question of who's responsible. Secondly, it could also be that the Commission is the one that is responsible for the violation. And again, then you would be mixing rules that you should really not be mixing. It could also be that, well, perhaps the applicant can't bring an action for annulment, and that would lead to uneven access to justice for the applicant as compared to the state. So you then get to the last and fifth option, the CJEU itself. So that seems to be the best option. And leaving the decision, you know, on responsibility to the CJEU would, of course, enable it to very carefully safeguard the EU's autonomy and also its own exclusive jurisdiction. And I propose that this question should be resolved by the CJEU before the Committee of Ministers starts to supervise the execution of a judgment. And this means, in other words, that you require a procedure for post-involvement. So we may sometimes need prior involvement, which I'll get in a bit, but you also need post-involvement by the CJEU when the co-respondent mechanism applies. And at this point of my presentation, you may wonder, but we were talking about unilateral declarations and friendly settlements. Have you forgotten about that? No, I'll return to them now. So my idea is that the ECTHR could facilitate the post-involvement by the CJEU by adopting a judgment on the question of a violation alone. This will be a legal fiction, I guess, but I don't think it has another way or to go about this, considering the content of Opinion 213. So we'll then leave the question of responsibility in Article 41, just satisfaction, to the CJEU, which can then resolve this question. And the European Court of Human Rights could then adopt a decision based on a friendly settlement, basically rubber stamping the CJEU's solution. I think a friendly settlement or a decision based on a friendly settlement would be more appropriate than an actual judgment on this question, because there's no room to judge, really. It would simply be rubber stamping whatever the CJEU proposed. In my paper, I also deal with some procedural changes that would be required to facilitate this proposal, but I'll leave them aside for now. I'll now move on to the third scenario, the third and last scenario in which EU law may play a role after accession, and that is when there's prior involvement by the CJEU. And the EU may become involved when the co-respondent mechanism applies, when it has not yet assessed the compatibility of a relevant provision of EU law with fundamental rights law. And if that is the case, the CJEU is given the possibility to deal with this question, to resolve this question before the ECHR looks at it, all in order to preserve its exclusive jurisdiction. And what I propose, and what others, as I put on a slide, have also proposed, is that if the CJEU finds a violation of a provision of EU law with fundamental rights law, the parties can then negotiate a friendly settlement on that basis in order to deal with the case, and the ECTHR can approve it. And this could be a way to then, deal with the fact that the CJEU has resolved the issue in a way. And well, the downside, of course, is that here you give the EU quite a lot of power. It decides on applying the co-respondent mechanism, decides on getting the CJEU on board and the prior involvement of the CJEU. And the CJEU then also resolves the question of a violation. And the idea of accession is, of course, to subject the EU to external review. But I guess that, well, this is what it will be like in order to make sure that we will not have a comparable opinion by the CJEU again. So, well, thank you once more for organizing this workshop. And for those of you who are interested in my paper, my email's on the slide, and I'm looking forward to your comments. Thank you.
Thank you so much, Liz. Very interesting. And for those of you who are interested in Liz's paper, I think they should get access to your journal, because this is where it will be published. So the third speaker is Vasilis. I don't need to give him the floor. He has already taken it. So. Thank you, Vasily.
You're welcome. Give me 2 minutes to do all the things we need to do. With the new one. So let me thank you from my side for this very interesting and informative workshop, and also for giving us the opportunity to come together and discuss these issues, and especially the two colleagues that they had the idea and they organized the conference. A little bit only. Today I will try to present some questions concerning the correspondent mechanism and the idea of proper administration of justice. Let me start by saying that this is a work in progress, a work that no one has seen yet. Because it has not been fully written. And some of the ideas that I will be presenting are still at a stage of reflection. and I will even showcase elements where more research needs to be done, or perhaps the assistance of our beloved processualists could be of some help here. So in my presentation, I will first pinpoint the amendments in the correspondent mechanism after the revamped 2023 Draft Accession Agreement. Then I will, parallelly, actually, I will inquire on the impact of those modifications upon the rights of the applicant and on the role and the process of the European Court of Human Rights. And then in a third part, I will try to highlight different kinds of scenarii, different kinds of strategies that might exist, and different kinds of arguments that might exist in order to counter some unintended consequences that the use of the correspondent mechanism might cause, the use or perhaps the abuse of the correspondent mechanism by the European Union, but also the use in a bad faith scenario, let's say. Let me very briefly remind the terms of the EU accession to the European Convention of Human Rights, because it is always important to have these terms in mind, as they will play some role in some of my explanations. Any adjustments to the convention system should be kept to the strictly minimal, and the equal footing of the parties, the equality of arms, the equality of parties needs to be respected as much as possible. A very crucial element is that the application will need to be addressed to the correct respondent. And of course, the agreement needs to present the specific characteristics of the Union and not affect the EU competences or the EU powers of the powers of the EU institutions, and of course respect the autonomy of the Union legal order. With regard to the responsibility question, the Draft Accession Agreement makes, we need to distinguish between attributing the international wrongful act to the Union or to member states or to both, dual attribution, and on the other side, determining the respondent party. And we will see that this in the Draft Accession Agreement is not necessarily interlinked. So you might have some issues of having a respondent, as I will explain later, who is not the one to which the act is attributed, and that can pose a problem. And the two particular traits of the Union that complexify a little bit more the problem is that the Union has some shifting competences, and the Union's competence gradually increase, and you have this phenomenon of executive federalism where the Union decides, but the member states many times are called upon to implement. And that, of course, makes these discussions a little bit more complicated. Now, starting with the responsibility issue, we see here the main two rules of the Draft Accession Agreement concerning responsibility. And we can see that in the 2023 agreement, there is no change in those two rules. I think, although it is not very clear in the agreement, I feel that actually both for the Union and for the EU member states, it is paragraph 4 that deals with the issue concerning member states directly and explicitly, concerning the Union indirectly in the explanatory report, which is integral part of the Draft Accession Agreement. And the rule is a rule of factual attribution. So despite the variations that you have in the two paragraphs and the fact that for the Union we don't really have a clear rule of attribution while we have for the EU member states, the rule seems to be factual, meaning whoever did the act, if it is a member state organ, it is the member state to which the act is attributed. If it is an EU institution, it is the EU to which the act is attributed. And this is a rule that it is mainly used also by the European Court of Human Rights, so it doesn't seem to be such a big issue. But we see there in the in the second sentence of Article 1, paragraph 4, that the Union can become, does not preclude this rule of attribution, of actual attribution, does not preclude the Union from being responsible as a correspondent for a violation resulting from those acts, measures, etc. So what you have here is the possibility, although the act is attributed to the member states, the Union to come and become correspondent in order to share responsibility of or in specific scenario. Now, going to the correspondent mechanism, I will focus on three main issues / problems: the activation of the mechanism, the termination of the mechanism, and the issue of joint responsibility. Starting with the activation of the mechanism, we can see that in the 2023 agreement, the actual rule of when the EU may become a correspondent has not changed, has remained intact, but the change has been brought in paragraph 5, which, while in the 2013 agreement allowed the court, the Strasbourg court, to do a plausibility test in order to see whether it is plausible, the claim to become correspondent, this has been changed. And this change has led to a substitution of that plausibility rule with two possibilities which existed already in the previous version. First, that the court can invite the European Union to become correspondent, or the European Union, by its own initiative, request to become a correspondent. Now, here you have different issues. For instance, what kind of legal nature the invitation to the Union will have in order to become a correspondent. If it is the Union that requests to become a correspondent, we see here in the new version that there will be afterwards a decision of the court granting, we don't see it in paragraph 5, but in the draft explanatory report, there will be a decision of the court allowing, admitting the correspondent. What is the legal nature of that decision? Are these decisions possible subject to challenge, to legal challenge, or not at all? This is an issue that perhaps needs a little bit more reflection. So in order for the Union to become correspondent, to activate the mechanism, according to the draft explanatory report, you need to have a reasoned assessment, both with regard to the invitation, after it receives the invitation by the court, you need to have a reasoned assessment, and then the Union will become correspondent, and also when it decides by its own initiative to request to become a correspondent, it needs to have a reasoned assessment. That reasoned assessment, according to the draft explanatory report, is, and here is the juicy part, determinative and authoritative, meaning that the Union itself decides whether it will become a correspondent or not. And afterwards, the court simply executes that reasoned assessment in a way. It retains, however, the court discretion in other aspects apart from the reasoning of the assessment concerning correspondenship to shape the way the correspondent mechanism will be unfold. For instance, the draft explanatory report says the court will decide when accepting the correspondentship, whether legal aid needs to be given to that person concerning the correspondent, etc., etc. So we see here that the European Court of Human Rights keeps absolutely no power with regard to the part of whether the correspondent mechanism should be activated or not. The court, as we heard already, rubber stamps the reasoned assessment of the European Union. It doesn't make its own assessments, and that is in order to avoid impinging upon the autonomy of the Union legal order. There is, of course, another issue which is touched upon a little bit. What will happen if the Commission makes a reasoned assessment and then the correspondent refuses to join? For instance, that reasoned assessment might come also on the reverse scenario, where it is the EU member states that request to join an application that was addressed initially only to the European Union. Here, there are some developments, reflections in the draft explanatory report, and there is also Appendix 2 to the draft accession agreement, which says that if there is a reasoned assessment that says you need to become a correspondent, then the Union and the member states will do it. It's like that. It doesn't say they are obliged to do it, they will do it. So there too, I have still some worries whether that in a bad faith scenario, once again, will work as smoothly as it seems, as it is described, let's say, in the explanatory report, etc. What role remains for the court is to inform the parties on the reasoned assessment of the European Union. So the Union reasons, it sends the reasoned assessment to the court informs the other parties, and then the other parties issue some possible comments where commenting on the reasoned assessment of the European Union. And the court will once again send as a must send those comments of the parties to the European Union, which has the discretion if it wants to reply or not, which also seems to be a little bit surprising. For instance, why don't we wait those comments of the parties to come perhaps also before the reasoned assessment, so that the Union can take them into account when it assesses whether it will become a correspondent or not? And why don't we force the Union, we don't impose an obligation to reply to those comments after the reasoned assessment, but only give to the Union, as we say, discretion to reply or not. So here you see a little bit those various issues concerning how the mechanism will work. So I will focus only on the last point, that it seems from this description that the European Court of Human Rights cannot challenge the assessment of the European Union as arbitrary or comment on it on any reasons of substance concerning the reasons that the European Union has invoked, cannot comment at all on the reasoned decision assessment, although in previous versions during the negotiations from 2020 to 2023, there were broader assessment powers to the court, and the European Union asked for them to be deleted. And you also have here, as we see, that the applicant cannot comment, but only after the reasoned assessment. Going now to the second part concerning termination, here we have a new addition to the draft accession agreement, which until in the previous version of the 2013 was only part of the draft explanatory report, paragraph 59. Now it is a paragraph of Article 3, so it is given perhaps a little bit more attention and more significance. And it says that the court will be able to terminate the correspondent mechanism through a decision only if there is a reasoned assessment by the European Union saying that the conditions under paragraphs 2 and 3, the ones that need to be fulfilled to become a correspondent, are no longer met. So there is no more need for a correspondent, or things have changed, or I don't know what exactly. In this situation too, the court will communicate the decision terminating the correspondentship to the parties, and before the correspondent mechanism is terminated, so perhaps it shall the reasoned assessment, probably it will communicate to the parties. And before the correspondent mechanism is terminated, the court will grant the applicant the opportunity to be heard about this situation. Now, in the explanatory report, two issues are given in order to justify the termination of the correspondent mechanism. If the state, the party that it is correspondent, is neither responsible for the violation or not capable of remedying the violation. In those two situations, and I assume strictly only in those two situations, the European Union will be able to terminate the correspondent mechanism. After the court receives the views of the applicant, the explanatory report states that it will once again address those views to the European Union and give the European Union the opportunity to reconsider the assessment leading to the termination of the correspondent mechanism in light of these comments. Finally, concerning the mechanism, so we see here a little bit the various elements regarding how the termination will take place. So initially, the European Court of Human Rights has kept a so-called of last word, but in the final version of the 2023 agreement, the Court of Strasbourg is obliged to terminate upon receiving the assessment of the European Union and after the views of the applicants have been heard. But of course, there is no obligation to take into account those views or to have those views of the applicant influence the outcome in any way whatsoever. Now, going finally to the joint responsibility provision, the only big change is that the Court of Strasbourg cannot diverge from the joint responsibility result in case the correspondent mechanism remains active until the end. While in the previous version, the court had the possibility to assess and not allocate jointly responsibility, but decide differently. This is not anymore a possibility for the court. The court is obliged to find both the respondent and the correspondent as jointly responsible. Now, let me go to my last part of the presentation, which concerns the various issues that might be created if you have an abuse of the correspondent mechanism or perhaps a bad faith invocation or termination, etc., etc. I have raised some of the issues. What is the legal nature of some of these procedural steps that take place? Can someone challenge in one way or another the reasoned assessment? It seems no, that's not possible. Can someone challenge the decisions of the European Court of Human Rights? That also doesn't seem possible. It's not really a type of remedy or of process that exists in any way in the normal procedures before the European Court of Human Rights. So I assume this is not possible. Another question is that all these mechanisms lead to some of the issues being regulated through inter se arrangements within the Union, by the Union and its member states. So they decide who is going to be respondent, they decide how responsibility, of course, will be allocated, because on the basis of the correspondent mechanism, we have also fixed result concerning responsibility, joint responsibility. They might decide also some other issues that are related to respondenship and responsibility. And of course, one wonders if those inter se arrangements that need also to be put into place, how these decisions will be reached. Would it be the Commission? Would it be the Council? Would it be a connection of the two? It will be the legal affairs of the European Union. It will be the Court of Luxembourg. Who is going to do all that? If these inter se arrangements are contrary to the Draft Accession Agreement, what will happen, how these two will be compromised and coordinated. A second issue is if these inter se arrangements are rather far-fetched, create a very complex system in order for the Union to reach these reasoned assessments, for instance. Can you really say that the other member states of the Council of Europe, which consented to the draft explanatory report and the draft accession agreement, and to the existence of inter se arrangements, but not to the content of those inter se arrangements, have they really consented to those arrangements if they are very far-fetched, and so on and so forth? And the third is, can in any way possible the European Court of Human Rights review those inter se arrangements based on the fact that they are mentioned in the draft explanatory report, over which the European Court of Human Rights has some jurisdiction to review how it is applied, etc., etc. These are simple questions that I'm raising without really being able to give definitive answers about these issues. Let me now go to my last two slides that highlight in the biggest problems on my side, because this is a little bit too theoretical and too public international law, what I just mentioned. I try to argue that there are two main issues concerning the mechanism as I described it beforehand. The first has to do with the judicial function of the Court of Strasbourg. And in my view, the way the mechanism has been created leads to an undermining, to put it rather mildly, of the judicial function of the European Court of Human Rights. Thus, I argue, for instance, that part of the judicial function, and here the processualists can be of help, is that a court needs to assess the dispute independently, also to encourage, reach that assessment through adversarial proceedings, meaning that it needs to hear also both sides on those different issues, and also that the courts, and especially the European Court of Human Rights, has an inherent power, and this, I argue, is an inherent power of every court, to decide itself the parties to the conflict. Who is going to be, when the dispute comes, obviously the applicant is decided, is determined, but concerning and of course through the application we already have a respondent, but the court needs to be able to decide whether this is the correct respondent or someone else should be, thus reject as inadmissible ratione personae the application. Say the correct respondent is not here, this respondent has not violated the convention, there is a ratione personae inadmissibility. There is no violation here, not the correct respondent is in front of me. So this is a power that I consider that it is an inherent power of every court, that if it is taken away, my argument is that the court is not anymore a court. That there are serious issues, and someone can be inspired also by public international law and the monetary gold case, where the court has a little bit touched upon that issue of having the correct respondent there. The indispensable third parties, whether they are simply indispensable or whether they should be respondents in those cases. And I think this is a topic where if I get some encouragement, more encouragement, I intend to try to go further and try to see whether we can find some arguments, and sorry for that. Thank you for that. This was, here it is. Here, I would say a few words, if I am allowed, some more words. This concern, obviously, I need to say from the beginning, the vast majority of the scenario that we can think, and I would say the normal approach would be for the European Union to be a good faith player that will use the mechanism as they were intended, and there will be no twisting or abusing of the mechanisms. But I think it's a little bit oversimplifying the situation to think that the European Union or its member states are always a rational actor that will act rationally and they will follow the rules to their letter. It's very probable, not very probable, that there might be also situations where these rules will be abused or will be used in a bad faith. So this concern, in my opinion, is not such an exaggeration under the Draft Accession Agreement. By overriding the interpretative and judicial authority of the European Court of Human Rights and by depriving it of the competence to specify the proper respondent, allocate responsibility, and determine the appropriate remedies for the execution of its judgment, this creates this denial also of the power to rule on the substance of the legal standing question, creates a tangible danger of the court being called upon to adjudicate fictitious disputes. The union becoming correspondent, switching positions, and then staying alone while it was the member state that had violated, and decide to terminate the correspondentship for the member state of understanding during the proceedings that it will be accused, the union, about the situation and terminating that correspondent mechanism. So these fictitious disputes is a possibility, not a big one, but still. The proposals undermine the court's independence as they allow an interested disputing party to determine who will be the respondent in an application. So it will be the one that has stakes on the decision, manipulating the processes in order to avoid being found responsible. And additionally, the principle of adversariality is fundamentally compromised since the applicant cannot fully challenge the EU's respondent determination, as we have seen. The current text seems to be undermining the principle of equal footing, which is deemed to be one of the cornerstones of the negotiation. Can such issues be remedied on the basis of the Strasbourg Court's assertive stance? Can the court, after the accession takes place, become more assertive in order to control that these mechanisms will never be abused or used in a bad faith? For instance, what would be the practical consequences of imposing to the court a respondent? Could the Court of Strasbourg employ its inherent powers in order to determine whether the respondent before it is the true party to the conflict and thus find the case inadmissible if the allegedly wrongful conduct is not attributable to the respondent that has been left in front of the court? In other words, does the court's examination of the facts not apply as a corrective mechanism leading to eventual non-admissibility or non-violation decisions? Say, on the basis of those facts, the one that is presented as a respondent is not the one that has, to which I can attribute the act or I recognize a responsibility, and thus there is no violation or something like that. Would that be good for the applicant's quest of justice? It's also a question to be reflected upon. Finally, I think here one could perhaps reflect on issues such as the due process of all that procedure, the result assessment, etc., whether we can impose some due process guarantees in all that procedure, which seems less judicial but more administrative or something like that, on and also take, perhaps see how CETA will unfold, because it has also a determination of respondent mechanism, the agreement with Canada, and see whether there, the mechanisms and the inter se arrangements that are used are can be also used in the case of the accession to the European Convention of Human Rights. Now, going to my last point, the applicant's rights, this is the second point of concern. We already spoke about the court and losing some aspect of its judicial function. The second is, does that impinge on the rights of the applicant? I think that the applicant will find itself after the agreement in an unequal position vis-à-vis the European Union and its member states, because it will have the possibility only to express his or her views after the EU's reasoned assessments. It will be deprived, perhaps, of the correct respondent in case there is an abusive termination of correspondent status. The question is, how can you invoke these elements in front of the procedures of the European Court of Human Rights? And here I have made some initial only reflections. Already, the Luxembourg court, with the occasion of CETA, in opinion 117, has said that if the very essence of the right to individual petition is preserved, then the mechanism is acceptable under EU law. Should also the European Court of Human Rights do an analogous assessment, see whether after putting into function the accession agreement and all the inter se arrangements, the very essence of the right to individual petition of the applicant is still preserved or not? Can the court do it, or can the applicant raise such an argument before the court? Another way of putting that would be to start developing more this notion that there is a human right of access to international justice. This is quite far-fetched, I know, but there are some authors like Cansado Trindade that has insisted about the existence not simply of a right to individual petition, but perhaps of a human right to individual petition in front of an international court or tribunal. And the question is, can you limit that right to individual petition before the Court of Strasbourg through an international agreement like the Draft Accession Agreement, in the way that some states limited that right through domestic law and they were condemned in front of Strasbourg? That's simply a question. And finally, I don't think that the theory of acquired or vested rights will help in front of the Strasbourg court the applicant, because it's not really an idea shared by the court, but perhaps an effort to implement or apply tangibly the principle of non-retrogression of human rights. Could that also help the applicant argue that these elements of the agreement are an unacceptable limitation to the right to individual petition and should be sorted out by the court? These are some questions that I have put in front of you. Let me say that there is more research that needs to be done concerning how the European Court of, what kind of tools the European Court of Human Rights has or might have after the accession in order to counter any such possible abuses of the draft accession agreement by the European Union and its member states, and also how the applicant can defend against such and how, what kind of procedural tools might have the applicant, objections, claims, etc. What kind, when the applicant should be raising those issues, admissibility, merits, although usually they are joint and fusioned, you never know how that will play out after the accession agreement, whether these are issues of procedure or even of substance concerning the rights of the applicant, whether Article 6 of the Convention can also be extended to those issues concerning the rights of the applicant, and whether these arguments that I have just mentioned are really appropriate in front of the European Court of Human Rights, because some of them I have a lot of doubts whether they can be really even articulated before the court. So I know it was quite long, but I tried to serve the purpose of playing defense with time. But thank you very much for your patience and your attention.
On behalf of parties, thank you very much for filibustering. I would suggest we take a first round of questions, and then I would invite Professor Koutenidis maybe to join us, and we'll continue with.
We don't have a microphone. We just let me ask the person that it is helping us with the technology in the room. Do we have a microphone in order to get questions from the audience, whether from the audience online, that we don't need a microphone because they will write, but from the audience here in the room, do we have something like that? Because I understand that there are no microphones in your seats next to you, nothing. So we should have one normally, because otherwise, or perhaps this big thing is the microphone there that you have there in the middle. Well, if somebody wants to ask a question, go to the floor. I know it's lamp. Okay.
Yeah, but they can just pick up and it will be okay.
So,
who would like to take the floor? And if not, I have questions to ask, but come on, don't be shy. Anyone? No? Okay, I'll ask some questions. First of all, I'd like to thank all three speakers. Question number one for Christine. You've covered before that, let me make again a step back. I hope that these three presentations show that the initial point that I made. We have this concept of joint responsibility, which to me looks quite artificial. Step back. Shared responsibility is a concept we have in international law when you have more than one states or actors that are liable. Shared responsibility has certain subcategories. Joint responsibility that we're talking about here, it's just one of these subcategories, and it essentially applies only where we are unable to allocate responsibility, either because attribution or causality do not work. So you think of complex situations. But most of the cases that we'll be discussing about here are cases where a court, like the European Court of Human Rights, could allocate responsibility. And the whole purpose of these correspondent mechanisms, etc., is to prevent the court, and this is where Vasilis is raising the question of, are you still a court if you're prevented from doing this? So the question is how artificial this is. And going to Christine, you discussed a scenario which I find very interesting, and I think it might arise, that the EU and the member states disagree on the defense line, and they try, in a sense, to blame each other. Okay, for me this will be very interesting. This will be popcorn time. You just sit down and it's like a couple fighting. Okay, but what about another scenario? Can I, as an applicant, point the finger and say, well, it is not the EU. All the evidence I have and what I'm able to prove is that it was the member state, or vice versa? Or should, as an applicant, be prevented from doing this? Because even if the court abstains from putting this in the decision, when the court will say, well, the applicant claimed this, etc., this will be already allocation of responsibility. So this would be my question. Then I have a small question for you, Vasilis. You use the term factual attribution. What would you mean by factual attribution? And the reason why I'm asking is my understanding is that the rules on state responsibility, you can classify them in two categories. You have attribution, which is factual and causality implying. And then you have de jure attribution. Okay, so is this the context in which you use the term? And then a common question to both Liz and Vasilis. You've described the role of the EU organs, and in particular the Commission, and in your case, Commission and Court of Justice of the European Union. But, and maybe this is also a question to you, Professor Ktenidis. So in the end, the Commission is omnipotent in this procedure. It decides when the correspondent mechanism will apply. It decides if joint responsibility will apply. It decides about friendly settlements. What is the place of the member state in all this? You raise the issue of the court, so we are in a sense, curtailing the role of the court, etc. But what about the member state? And I don't know whether I should say this in front of David, but to some extent, I'm even surprised that states agree to this, because they are giving all the power to the Commission to decide about them, if they are liable, if they can have a friendly settlement, and so on and so forth, how evidence will be used. So states are giving lots of power probably to the Commission in not only in respect to the activation of the or the termination of the correspondent mechanism, but also in regard to proceedings. So you'll have 15 to 20 minutes each one of you while we're waiting for Zainab.
Yeah. Forgive me, I'm feeling a little bit unwell, so if I have to go and sit at the back again, that's why. It's fine, I'll answer. Yeah. It's an interesting question. I mean, it's something that I thought about, because when I was writing paper, the applicant is sort of sidelined because we're talking about all these procedural dimensions, and we're not actually talking about the person whose rights are, allegedly or actually violated. So, yeah, I mean, your question really is about whether the applicant can insist on a certain attribution of responsibility, isn't it? Now, the court will very often indicate the facts as alleged by the applicant, and it might take those facts as its start point. I don't think it's for the applicant fully to that it would be the applicant ultimately that was be making that kind of judgment call. That's the court itself. But I think that the applicant is in a strong position that the court might have to take that on board. But I think as soon as you get the detail of, well, what's being alleged here, what do we think the violation is here, you have to start to look at, well, you have to look at cause. It's inescapable. The court can't find a violation without finding cause. And one of the reasons I'd say that, where it's got such a high standard of proof, it has to be, okay, it's beyond reasonable doubt. It certainly tries to be satisfied to the highest degree of certainty it can possibly attain, and it draws from different sources as well, and it triangulates its sources, which I probably didn't make enough of that when I was talking, but because it does that, I don't think it will be ultimately the applicant that's decisive in it, because it will be the court, and the court will decide how much credence and how much to give to the applicant's account of things, and how much to pull in, and how much credence to give to other factors drawn from other sources as they might be. So, I mean, obviously talking very much in the abstract, and there's quite a spectrum of rights that might be we could talk about, and qualified rights I think we probably would talk about slightly differently to your absolutes. But yeah, I think it is the applicant is the start point in this, but it would ultimately be the court when they're pulling bits apart. You can't establish that there's a violation without actually being able to say what the violation is. So that causative dimension is key, and that's why I've said joint responsibility. Okay, it's a thing in terms of the outcome of the case, the stated outcome. Well, you've got people like us, and we'll look at the judgments and we'll draw our own conclusions, and so we'll then in academic writing be attributing responsibility just from being led by what the court has said, even if the court's not prepared to say, okay, definitely it's the European Union or definitely it's the member state. It might be both. Yeah, yeah.
Thank you so much.
Yeah, so you were wondering about the role of the member states, and also why have they agreed? And I found it even more surprising, actually, that the non-EU member states agreed to all of this. The EU member states I can kind of understand to some extent, but even the non-EU member states, and I've heard like people who are very like into the Council of Europe and are from Turkey, and they were also rather surprised. They were like, well, how come that they managed to do this? And indeed, their role is rather limited, I would say, especially when these special procedures apply. Although the explanatory report to the draft accession agreement does say that both the states and the EU must agree to the unilateral declaration or friendly settlement. So there it has a role, but it's of course a rather minor role compared to deciding on, starting the co-respondent mechanism or making sure that the CJEU becomes involved. And I was just actually wondering if I may also ask a question, because the CJEU will be able to give an opinion, but what about ECTHR? Have there, and that's mainly a question I think for you, and also listening to your story, it seems like the competences of the ECTHR are, well, rather are reduced in a way. CJEU will be able to give its opinion, and the Strasbourg court can't, I think, or at least when the previous accession agreement was negotiated. I'm not sure how much the court was involved. I was wondering perhaps whether you could perhaps say something about the courts, the Strasbourg court's involvement, and whether it was able to have a say or perhaps say something afterwards. Really curious about that. If you can say anything about that at all.
Would you like to take the floor now, maybe? Yeah.
Yes.
Well, the meetings of the negotiation group were closed meetings. They weren't public meetings. And there were a limited number of participants who were convened to these meetings. More limited than is usually the case for intergovernmental committees. The Parliamentary Assembly, for example, did not participate in the negotiations. Although in any other work which is done under the authority of the Steering Committee for Human Rights, the Assembly and a whole load of other Council of Europe bodies and external actors as well have a right to participate in the meetings, not in the negotiation meetings. But the court, yes. The court was there, very present, very active, and very much listened to throughout the negotiations. So the court's voice has been heard. Nothing has been agreed to which the court made objections. Obviously, a lot of the discussions were not entirely in the public parts of the meetings. You won't find any reflection of everything that's said in the meeting reports. These were international negotiations. That is normal. So maybe some of the tricky things were ironed out over coffee. But the court was heard. It was there. The court will not be involved in the adoption of the accession agreement, whenever that happens. The question is, before adoption, will it be asked for its opinion? The expectation very strongly is that the Parliamentary Assembly will be asked for its opinion because there is a Committee of Ministers resolution which commits the Committee of Ministers to always asking the Parliamentary Assembly its opinion on any draft binding agreement, treaty, convention, or something like this. So that is expected. There was discussion of the possibility of the court being asked for its opinion. This discussion was not conclusive, and I think there's an open question about what would be the legal basis for the court's jurisdiction in this area. There are two ways in which the court can give opinions, but they both relate to the convention itself. The Committee of Ministers can ask the court its opinion on convention issues that do not concern the interpretation or application of the rights. So, for example, issues relating to the election of judges, the court has given an opinion on that to the Committee of Ministers. Or under Protocol 16, the court can give an opinion to a national court, and this time on, and only on, a question of interpretation and application of the rights. It's not clear on what basis it could give an opinion at the request of the Committee of Ministers on something like this, an intergovernmental agreement. That's not to say it's impossible, but it's a question which hasn't been resolved. So that's all I can say, really. The possibility is being floated, but I wouldn't say there's an expectation that it will necessarily happen.
With regard to the attribution question, I would say that what the agreement tries to do is avoid completely any discussion about normative control in the attribution question, meaning that if we consider that the one that has acted is the state, its organs, agencies, etc., or someone under the factual control of the state, then the attribution goes to the state. And conversely, the same for the union, if it is someone under the factual control of the union. In order to avoid that this discussion that when member states act under strict obligations of the union, they are considered EU organs, I think they wanted completely to exclude this kind of discussion because it will complexify the issues even more. So this is what I call here the factual attribution element. Now, concerning the role of the Commission, it's quite interesting how this will work, but I'm not obviously the one to be able to answer that, but I would insist that it is important to see what kind of due process guarantees will be put in that in these processes within the Commission, so that the end results are satisfactory, are the ones intended by the Draft Accession Agreement.
To say a word on this comment or to make
Both.
both? Okay. So I will start, and in the course I will also discuss this comment. I will start naturally by thanking the organizers, Professor Zevelekos, Professor Vantakis, Professor Pergandis, for this very challenging workshop on a very hot issue. And also I will take the opportunity to say that I'm very excited that we are co-organizing our law school, this workshop, with the law school of the University of Liverpool. And I consider this as a part of the celebrations for the title that Liverpool has won this year. And I will extend also my...
PAOK did not do it.
PAOK did not do it, but we did last year. You cannot have everything in life. You should compromise. And I will extend also my congratulations to prominent members of the Manchester United family who are also in this group for avoiding relegation this year, which was also very important. So having made things a little bit lighter, I hope, from all these heavy legal discussions we are having, I'm going to contribute to this very high level, I would say, legal discussion that has been developed until now with a with some small comments. And I have arranged to organize my comments on the basis of the title of the workshop, which uses the word hurdles regarding the procedure that will be followed after accession. And I am a little bit skeptical about this term. And I will go back to that, but I think that if we are thinking of obstacles in the procedure, obviously before the Court of Human Rights, we should identify from what perspective we are addressing this question. And I would address the question from the perspective of the applicant. So which are the obstacles for the applicant? Because it is undisputable that after accession, the Court of Human Rights shall be having considerable problems in applying the convention in these cases. So it will be facing serious hurdles in adjudicating the cases. The European Union and the member states shall also be facing a number of problems in the application of this agreement, which they have to deal with. I think the problems for the European Union after the adoption, hopefully, of the accession agreement are going to be very significant. It is going to be a very difficult agreement to apply for the Union and the member states, more difficult than this shall be for the Court of Human Rights itself, I guess. But I will not discuss those because I will look at the procedure from the perspective of the applicant. And I will take into account also the statement that was made in the beginning by Mr. Yakoumopoulos that the European Union has been treated as a privileged party in this process, which I would question a little bit. Not that it has been treated as a disprivileged, or it has been, but I would have to identify the privileges. Now, for the applicant, after accession, I think that there will be a scenario, because all this discussion is based on scenarios. I will use the scenarios mainly as they have been described by Professor Glass. And I will call the one scenario the basic scenario, or the important scenario. This is the scenario in which the applicant complains for an act that is attributable, according to the rule of attribution, to the European Union. So this, for me, this is the basic scenario because these applications are inadmissible today. So this is the basic gap which is filled by the accession, that the Union can be held liable for breach of the Convention. And this is not an issue to underestimate because there are there is a lot of litigation of direct actions before the Court of Justice of the European Union involving human rights issues. All this litigation finishes in Luxembourg without the control of the Strasbourg Court. This gap, this is a serious gap in the EU legal protection system, which shall be closed after accession. In this basic scenario, I think for the applicant, there is no procedural challenge, no hurdle. It is the Union shall be in the same position as any contracting state as a respondent in this scenario, and it will be in, there are also from the discussion that I've heard, there will be no burden of proof differentiation, and I don't see why in this prospect there is any privilege of the Union. However, the Union might claim as a respondent, might claim, we know that in some cases the Union's defense in this case shall be that I cannot do otherwise because I'm bound by primary law and I'm not responsible for primary law because this is drafted by the member states. In this case, actually the correspondent mechanism might be triggered. In the literature, I read that this is a very exceptional scenario. I don't think so. I think it's going to be one of the first cases that will reach the Court of Human Rights after accession, which will be dealing with the standing requirements of individuals before the Court of Justice of the European Union in direct actions, especially in actions for annulment. This is an issue which is as old as the European Union itself. There is always this limited standing of individuals before the Court of Justice. It is always the interpretation of the European Court of Justice that this is because of the wording of the treaties. The treaties have been amended, things didn't change dramatically, and there is always the complaint that this provision of the treaty, Article 263, is in violation of the Convention. So I think that this will be one of the first cases, normally, from our expectations, that will reach the first question, that will reach the Court of Human Rights, and in which the correspondent mechanism will be activated and the member states will be invited to participate in the proceedings and join as a correspondent. The decision that the conditions are met and the member states should join as correspondent is with the union. I don't think that at this point it is clear which institution will take that decision. However, the mechanism is voluntary, meaning that a member state, even if there is a positive decision by the union that the conditions are met, and in this case, obviously, this will be so, one or more member states might not join, if I'm not wrong, in my understanding of the convention, against the decision of the union. In that case, the member states shall be in breach of EU law, but this is an internal EU law matter. That member state shall not be a party in the dispute, and it shall not be bound by the decision. There will be no joint responsibility of that member state. Is that a problem for the applicant? Because I think this is what's going to happen. But the question is, does this put the applicant in a worse condition? Theoretically, it does, because if all the member states were forced to participate in the proceedings and were bound by the judgment, then eventually they would be under an obligation to amend the treaties. This goes too far, I think. I think what shall happen is that probably in such a case, because the union will definitely be bound by the judgment and would have to enforce it independently of the member states, there will be a change in the case law of the Court of Justice to accommodate this problem. So in this basic scenario, I think that the rights of the applicant are in no way jeopardized in the course of this agreement, irrespective of whether the correspondent mechanism applies or not. And also, I think that in this basic scenario, the Bosphorus presumption is irrelevant. It doesn't play any role, and I will come back to that. The more interesting scenario is the second scenario, in which the act is attributed to the member state. So, according to the Commission, according to the draft agreement, but also according to the law of the convention, even before the agreement. So, in that case, I think I consider this a secondary scenario, because those applications are not inadmissible today. Those applications are admissible today. They are just adjudicated under the Bosphorus presumption. The Bosphorus presumption is a presumption which has been elaborated by the Court of Human Rights. It's not EU law. It's Strasbourg law. When it was introduced in the middle of 2000, I don't know myself if I was very friendly with that presumption. I don't know if I would have introduced that presumption if I was sitting in Strasbourg. Being the law of the European Court of Human Rights, it is in the hands of the law of the Court of Human Rights and, of course, of the convention system to deal with that. It doesn't need an amendment of the convention, because it is case. And of course, during this accession, this long story of the accession, the presumption has been developed, and to a certain extent, it has its scope has been relatively diminished by the Court of Human Rights, and in the future, this might change. So, for the applicant to start with, the second scenario will be beneficial, definitely, because one would expect that the Court of Human Rights should abandon the Bosphorus presumption, because it wouldn't make sense. So, so the applicant would be in a better position after accession anyways. Of course, in this second scenario, if the act for which the applicant is complaining has been if the member state acted this way to fulfill an obligation under EU law, the question of the EU joining as co-respondent will arise. This is a process that is not triggered by the applicant. The applicant doesn't have a say in that, but the applicant has the respondent, which is the member state. So it is triggered, the procedure, either by the Court of Justice, the Court of Human Rights, by addressing the invitation, or by the union in itself. Still, it is a voluntary procedure for the union to join. This is what I understand. But this time, it is not in the same terms voluntary as we said it is for the member states, because now the union, if it considers itself not to be a correspondent, it should justify decision, because this is the reasoned opinion that it shall give on the matter of whether it shall become correspondent. It will be very strange if the union gives a reasoned opinion that the conditions for the correspondent mechanism to apply are fulfilled, and then the union decides not to participate. So mainly the union so it is voluntary, but here the union should give grounds. All these decisions of the union, if they are decisions by an institution other by the Court of Justice, this is a question that you asked, obviously shall be subject to an action for annulment, to review of legality before the Court of Justice. So there might be no such review before the Court of Human Rights, but there should be review on whether these conditions have been met, because these will be conditions of the accession agreement, which shall be part of EU law. So if the decision is taken by the Commission, it shall be subject to the review of the Court of Justice. But let's say that the union considers, abuses the process, doesn't want to participate, gives reasons, the Court of Justice goes with that, and the union is not, it does not become a party, is not a correspondent. What's the problem from the applicant? He will still have a good, valid decision against a member state, which is what he is asking for. And of course, the decision shall be executed, and the member state shall be bound by the decision. Obviously, by executing this decision, the member state will violate EU law. This is an internal problem of the European Union, and this is something that the union has to face. It is irrelevant for the applicant. The applicant will have a judgment by the Court of Human Rights, and the Committee of Ministers will supervise and enforce this judgment. The applicant will ask for will have a respondent as good as it can get. It will be a member state, whatever that means. But the union will have to arrange the matter internally, which is going to be a very complicated issue. This is why, in principle, the union, this is my understanding, will want to participate as a correspondent, because then the issue shall be solved jointly for both parties. And also, by joining as a correspondent, the prior involvement mechanism is triggered if the matter has not been brought before the Court of Justice of the European Union, which shall give the European Union to solve the issue internally, and then if the issue, and then to so if there is a violation, the Court of Justice, the European Court of Justice, will find the violation, and then the issue will be dealt at the level of the Human Rights Court, maybe through a friendly settlement or something else, without having to litigate on that. Is the fact that the union is joining, there might be cases in which the applicant might wish for the union to join as correspondent. I think that this would be mainly for to show that for declaratory purposes, to show that the blame is on the union. The applicant might have such an objective. If that is the case, I think, but I haven't elaborated much on that, that the applicant might use some technique of addressing, of directing the application against both the union and the member state, although that according to the act of attribution, to the rule of attribution, the act is attributable to the member state. In that case, I think the Court of Strasbourg might have some role to play, because it might notify the application also to the union, because the accession agreement provides that if the decision is directed and is against both the union and the member state, and it is notified to both of them, I assume by the Court of Human Rights, then the allocation, then the corresponding mechanism is triggered. And by notifying the application to the union, in this case, I think the Court of Human Rights will have made a preliminary assessment that somehow the correspondent mechanism should apply. And this shall be taken into account by the union when, by its own institutions, it shall decide authoritatively now on that. So this, if I have a case, I might try this way of making the union a party in the proceedings in this respect. But apart from that, I see no disadvantage for the applicant if the union joins as a correspondent. With respect to the burden of proof, the applicant has started a case against a member state. So whatever was the burden of proof that he had initially, this is what he will be having when the union shall join. The only difficulty is that the applicant will be facing two respondents. He has to litigate with two instead of one. This is the price the applicant is paying for getting a judgment against two respondents who are jointly responsible for its application. So I don't think that this is a serious disadvantage for the applicant. Obviously, if we get into that, the Bosporus presumption shall not apply. There is no reason for the Bosporus presumption to apply. So the burden of proof will be far better for the applicant in these instances. So having, how am I from, just a couple of minutes, do I? Okay, okay. Now, of course, there will always be room for abusing these rules by the union and by the member states and by the other members of the Council of Europe, by the other contracting parties. Well, in law, we draft the rules in a way we draft the legislation. Internally. One question is, which shall be the legal basis of this legislation, especially taking into account that there is no specific legal basis in the treaty allowing the union to legislate in matters regarding human rights protection. So probably it will be the international, the external action legal base, and this legislation shall be subject to litigation to start with. If someone, the members, this legislation, the legal basis shall dictate the procedure and what are the powers of the institutions in the legislative process within the European Union, and then it might instigate litigation within the European Union among the institutions with the member states involved, or who knows what, about these internal arrangements to start with. And then there should, and maybe I have no information about how the union is proceeding with that. I think, I don't know if you have any, if you know something about that, but I haven't seen something published. And there are many things that will have to, there are interesting things that will have to be fixed within EU law for the prior involvement mechanism, for which there is no legal base, for the attribution of liability, although the existing remedies within the EU legal order might provide some solutions. So it is a very complicated exercise for the union to participate. The thing is that, as was mentioned in the beginning of this workshop by Mr. Yakoumopoulos, and I agree with that, it's not an option for the union, because the union has to go and go again and go again through this exercise, because the participation is drafted by the member states as a mandatory task for the union. This is depending on what I say. If you like it, you press the button. If you don't like it, okay. So the union has an obligation. The contracting parties do not. So if they want to avoid the complications, they might object, not ratify the accession treaty. If they do, they shall have a new contracting party, which has many particularities. It's different than all the other contracting parties to start with, because it's not a sovereign state. So it's something else. You have a partner that you never had such a partner, and probably you shall never have another partner like that. So this is complicated. And until now, keeping themselves apart, the two systems, they have worked very efficiently apart. The Court of Justice of the European Union was very open to the case law of the Court of Human Rights from the 70s. It made the law of the Court of Human Rights its own law to cover a gap, but still that was what it did. It could have done something else. It could have looked into the national constitutions, but it didn't do that. It chose to rely on the Court of Human Rights. The Court of Human Rights was even more generous with the Bosphorus presumption. So they were both in very good terms with each other. Now, this is going to be more complicated, because the one partner, the EU, and its court, the Court of Justice, is in a much more difficult and stressed position than the Court of Human Rights. The Court of Justice of the European Union is trying to convince, is arguing for an idea of autonomy of a legal order, which is not autonomous, which relies on the member states, which constitute, the master of which legal order is somebody else, the member state. And it is always in a dialogue, which a few years ago led to a very strong confrontation with the German Constitutional Court, with the components trying to convince to verify the efficiency of the legal order, the legal nature of the legal order, that these are rules, the EU law rules, which actually apply in the territories of the member states on their own right. And to do that, it has to convince, not to convince courts that are courts of real sovereign states. So it's always in a position that it has to argue for a metaphysical idea of autonomy, and is always under the boundaries that are set by the member states with respect to accession explicitly by Article 8, by Protocol 8. So this is something that the Court of Human Rights obviously knows, the system, the convention system obviously knows, and I'm sure that they are willing now to cooperate with this new complicated partner. So, thank you. This is what I...
What I suggest we do is that if there are any comments or questions addressed to Professor Canadian, we take them down, and then we give the floor to David. And this also applies to the speakers. If you have any comments, I have quite a few, but I will give it myself. And Farid, by the way, you have given me the easier task. Usually chairs are the speakers. By the contrary, please speak more. So, anyone, any questions or? Yeah, let's see. What else? No, no. I had, if I may, a couple of comments. Autonomy, yes, I personally see the point, and indeed. Okay, yeah, Mr. Ekmopoulos, by all means. Please, you can have the floor. What's the... Yeah. Please take the floor if you can.
No, he can't. I don't think he can hear us. I think he...
Με ακούτε? Ήθελα απλά να πω το εξής, ακούγοντας τη συζήτηση. Sorry, listening to the discussion that took place before and the observation by Professor Tenidis, I just wanted to say that it is, in my view at least, unlikely that there will be a fight between a member state and the EU about to avoid responsibility. I would rather see the opposite, actually, that they might fight in order to establish responsibility, and they will claim responsibility, possibly exclusive one, on a specific human rights issue that will come. Responsibility means competence, competence means power, and actually this is what the Commission has tried to achieve in the draft agreement, to have this issue of distribution of competencies and responsibilities between the member state and the Union solved at the level of the Court of Justice rather than Strasbourg. And I think that this is what the agreement tries to do. It's not a question of who the two trying to avoid responsibility, and ultimately the court in Strasbourg will issue a judgment on someone who cannot cope with it or cannot implement the judgment. It's rather the contrary. What the Commission tried was to avoid that the fundamental issue of EU law, namely the competence, the distribution of competence between EU and the EU member state, is solved in Strasbourg rather than in Luxembourg. And I think that this is covered by the agreement as it stands now. Thanks.
Thank you very much, Christo. I'll call you so that you can hear us. And then... So I will skip, but do you want to respond to this or?
Well, I could say, if Mr. Giacomopoulos can hear me, I could say a couple of words. I wouldn't disagree that at least for the part of the EU, it should be willing to participate as a correspondent, as well as the member states. For the member states, it is not going to be that common, but for the union, it shall be common. And I think maybe the one reason that I think you mentioned it in one of your articles, that it is not very clearly stated if the correspondent mechanism shall apply only if there is discretion or not. I think this is phrased in that way, but you could tell us more about that, to give the union the possibility to join as a correspondent even when the Bosporus presumption, the previous Bosporus presumption, would not apply. So even in cases where member states has discretion, maybe the union would like to step in and share and have joint responsibility of the member state. And maybe this is the way this is drafted. This is the reason this is drafted this way. But why this is, and of course, I think it is completely justified that the question of division of powers, this comes directly out of Protocol 8, that the division of powers among the Union and the member states is not a matter for Strasbourg. It is a matter absolutely for Luxembourg. I think the first draft agreement in that part, it was not that carefully drafted. And it was very difficult for the Court of Justice to depart from the protocol number 8 in that respect. But why would it be detrimental for the, but I don't think it will be detrimental for the applicant to have another defendant, to have two who are responsible for the violation and have to comply with the judgment of the Court of Justice. I think that this is basically an advantage for the applicant, and through this mechanism, internal issues within the EU are being kind of mitigated.
Yeah, it's mainly a question because we will remark, I think, that responsibility leads to competence and to power. But then I was thinking again about your presentation, Vasilis, about bad faith on the side of the EU. So how would you respond then to what the other speaker said, that the EU may actually be eager to join? Do you agree, considering also what you told us, or not?
For instance, you might have a very improbable scenario, but you never know. The EU might join, and then according to, if I'm not mistaken, paragraph 4, they can switch status from respondent to correspondent and then terminate the correspondency for the other side, the member state who was the one being actually responsible, in order to make it that it is me that have the power, though it will not be able to remedy, for instance. You never know how these things will play. I don't say that this is a likable scenario, improbable scenario, but we have seen in various ways that lawfare, using law in order to manage to do something, can be used from various places that you would never imagine that they will use it like that. So you can never be sure. I feel that although I agree that the whole system as it was created, it was trying to insulate the European Court of Human Rights from all this bickering between, inter se bickering, is it your competence, it is mine, etc., etc. These things should have been decided beforehand or without really influencing the applicant and the court. There is a possibility that this will spill over to the procedure and then impact even on the applicant. These are scenarios that I don't know how you can. I don't say that the agreement should have been perhaps different, but we need to have them in mind and think how we can litigate such bad faith scenarios in front of the court if, and no one wishes that, they arrive before the court. Because you never know whether they will arrive, how the court can react, and what kind of remedies and rules you can use as an applicant in order to incite the court to react in a specific way and try to limit those kinds of scenarios and the impact on the procedure.
Vasilis, this is a very interesting comment, but I think that the drafters of the treaty, as all drafters of contracts, have been careful in avoiding possibilities of showing bad faith. I think that actually there can be, I presented this as an option by breaking the rule of attribution to bring the union into a case as an applicant. But why wouldn't I do this? Because then I run the risk that the union and the member states, then the member state that I'm addressing, they might decide themselves who is the respondent or the correspondent. Because why? Because I address I direct the application against both, which is something that I shouldn't do. If I do it as an applicant, I take this risk. If I want to be on the safe side, I apply the attribution rule and I file the application against either the member state or the union. And then there is no room for abuse of this provision because the choice is made by the applicant. And the applicant has the duty to identify who is the respondent. If he identifies, if he makes a mistake, he made a procedural mistake, and that's the problem, and it's his problem. If he wants to take his chances by identifying two as respondents, the union and the member state, then he goes into risky waters and he takes his chances. I explained that I might do this if I have a case, and I want for a reason which is incomprehensible. When I have France as a defendant, to include the European Union, why would I need that? I will have a judgment which will need to be enforced against France. If France was not a member of the European Union, why would this be a problematic situation?
Thank you so much. There are counter arguments, but I think we can discuss them over dinner. Delays in the procedure is one of them. As an applicant, you will need to wait. So this is already a major disadvantage. Execution is another one, but David, I think your 2 hours start now.
Well, I'm not going to take 2 hours, and given the time, I'll try and be as quick as possible. Before I enter into what are a little more prepared remarks, just to respond to a point which was just made, what is the disadvantage for an applicant if, for example, a case is brought against an EU member state and the EU, despite the declaration in Appendix 2 to the Draft Accession Agreement, declines to join the case as a co-respondent, even though the conditions in Article 3.2 are satisfied, even though the EU will have made a declaration committing itself to doing this, it doesn't. I think there could be a disadvantage at the execution stage, possibly also in the content of the judgment. But if it turns out, and presumably the absence of the EU as a co-respondent where it should have been a co-respondent would occur in these circumstances, the violation was because of EU law. The member state committed a violation as found in the judgment of the court, and the fact that there should have been a co-respondent in the person of the EU means that EU law forced the hand of the member state. It seems difficult. I think it might be possible for the court in its judgment to say, well, yes, there was a violation and France is responsible for the violation, but we note that France did this because EU law made it. That doesn't change its responsibility under the convention. But then what does the Committee of Ministers do when it comes to execute the judgment? Who does it ask to reform the EU law. It's not uncommon when there is a legislative component to the causation of the violation for the Committee of Ministers to call on the state to reform its law. The Committee of Ministers can't call on, in this case, France alone to reform EU law. So there, I think there would be a genuine need. And maybe this is why, to be honest, I can't answer this question. Maybe this is why we have a declaration by the EU saying we commit to always being a co-respondent when the conditions in Article 3.2, exactly, when the conditions in Article 3.2 are satisfied. We don't have a declaration by the EU member states saying that they will do that when the conditions in Article 3.3 are satisfied. So that was an isolated point. In response to what Vasilis said, I don't know everything about this, far from it. I would say I'm fairly well informed about the negotiations in Strasbourg, but I'm much less so about what's happening in Brussels. What's happening with the request for an opinion on the revised agreement, and what is happening with the development of the internal rules, which is the umbrella expression which the Commission uses for everything that it's going to put in place to administer within the EU, the co-respondent mechanism, joint responsibility, the way in which it will deal with the Committee of Ministers and the execution of judgments, determining the position of the EU and its member states when an execution against the EU is being supervised by the Committee of Ministers. All of these things which need action within the EU, but which don't need any reflection in the accession agreement or the convention or anything which has been negotiated in Brussels. Basically, the internal cuisine of the EU. Another more general point, it's important to distinguish what I think is a relatively straightforward question of legal principle, and that's why the co-respondent mechanism, why prior involvement, why joint responsibility? I think the answer is autonomy. From the consequences, are potentially more complicated in some ways, at least on a practical level, procedural consequences of implementing all of these things. These were a concern for the negotiators. There were concerns which were expressed quite forcefully towards the end of the process, and which a very, very attentive reader might see if one compares the appendices to different meeting reports and the ways in which quite fine points were added towards the end. So making sure that the court always appears to be the master of its own proceedings, that it's taking the decisions, even if it has no discretion in the decision that it takes, that it's communicating the results of its own work, that these are all things that are being done by the court. Most importantly, that whatever happens with a co-respondent mechanism or prior involvement or any of those things, the court retains absolute judicial discretion in determining whether there has been a violation. So all of these things were very carefully written into the accession agreement. But a lot of the other things are going to be done behind the veil of what will happen in Brussels. Behind the veil in the sense that they are not the business of the negotiation accessions, and they are not the business, directly at least, of the accession instruments. Although you see these occasional references to expedition, to things being done quickly, to things being done, I don't think the expression within a reasonable time is used, but certainly there was a lot of concern on the part of the negotiators that deciding whether or not the co-respondent mechanism applies, or for the Court of Justice to apply the prior involvement procedure, that these things should not unduly delay proceedings in Strasbourg, and certainly not be to the detriment of the position of individual applicants. The core of all of this is the joint responsibility mechanism. Is joint responsibility and the allocation of responsibility. I wonder, should one be looking, does it help not so much to look at the co-respondents as separate and independent actors, but rather as the internal elements of a consolidated EU structure. That where the co-respondent mechanism applies, both co-respondents are making contributions to an alleged violation, and the violation is the result of a necessary combination of these contributions. That there wouldn't have been the violation, in a sense, had there not been both of these actors involved. Had there not been somebody setting rules that the other party was obliged to apply, and then, much to its regret, causing a violation of the convention. The things go together, so they're not, from a convention perspective, distinguishable. Without both of them, the violation would not have happened in the way that it did. Maybe another way of looking at this, the co-respondent mechanism, can it be seen as reflecting a situation of legal duress? In a sense, you have one of the respondents saying of the co-respondent, he made me do it. The law that this other one imposed on me, or the law which exists and by which I'm obliged to act, meant that I had to do the thing that resulted in a violation. There seems to be a kind of element of legal duress there. But then you have Article 3, paragraphs 2 and 3, which use this word notably. And I'm unsure of the significance of this. It's been in there for a long, long time. So the co-respondent mechanism applies, notably where the violation could have been avoided only by disregarding an obligation. This is the kind of connection with Bosphorus. Now, the French word, I haven't checked this, but I suspect it's notamment, which can also be translated in English as in particular. I think if the English had said in particular, then it might be clearer that the violation could have been avoided only by disregarding an obligation is a necessary condition of the application of the co-respondent mechanism. Notably is a word which maybe leaves some doubt there. I think this will all be clarified by the way in which the EU seeks to have the co-respondent mechanism applied, and it will depend on the EU. I think the possibility for the court inviting a co-respondent to join will still be subject to the EU's determination of whether or not the conditions are satisfied. Some thoughts about what could be done to protect the position of applicants. For instance, in a situation where there's bad faith refusal to join a case as a co-respondent. I've already mentioned Appendix 2 and the declaration that the EU will make. But there's also Article 34 of the Convention. The high contracting parties undertake not to hinder in any way the effective exercise of the right of individual application. If it's arguable that the right of individual application is in some way made ineffective by the failure of the EU or a member state to join the case as a co-respondent, then possibly there's a separate complaint, a separate head of claim that could be made under Article 34. I'm only saying that Article 34 exists. I think it's a question that scholars in the first place, and then actors within the control mechanism of the convention system, including applicants and respondent states and in future the EU, would have to negotiate, because there are a lot of clever lawyers out there representing applicants, and we can see from the jurisprudence of the court that they will make every possible argument. And if I've thought of this, somebody else will have thought of this. Then there's Article 6, the right to trial within a reasonable time. There's a lot of conditions and requirements involved to allow this right to be exercised. I won't go through Article 6 to say what those are, but there is maybe a question about whether that could apply, for example, to the prior involvement procedure. If it takes too long, is there an argument that could be developed to say that the individual's right to trial within a reasonable time before you'd have to decide which jurisdiction is being interfered with? Because Zoe isn't here, I'll try quickly to say something about the problem with in the supervision of execution by the Committee of Ministers. But first of all, as an introduction to that, say something about what was the very peculiar dynamic of the accession negotiations. Now, normally you have an intergovernmental negotiation in the Council of Europe with 46 member states sending a representative, each with an individual national position. These may or may not coincide with the position of others, but there are no pre-established blocks. It's 46, all talking amongst themselves, facilitated by the Secretariat and a chair, but all on the same kind of level. But the 46 plus 1, as it's called, well, already you see that it's not 1, 1, 1, 1, 1, 1, 46 times. It's 46 plus 1. That's actually slightly misleading. It was more like 19 plus 1. The 19 being the non-EU member states and the 1 being the Commission that negotiates on behalf of the EU. Or even 1 plus 1 plus 1 plus 1 plus 1, 20 times, which is the 19 non-EU member states, which are not a coherent, cohesive bloc, and the Commission. But then behind all of this, in Brussels, you have the 27 group. The 27 who are deciding what the 1 will say. The 27 who are discussing amongst themselves to give a negotiating mandate to the European Commission and refining that mandate as negotiations proceed. And this again is something which is behind the Brussels veil. And this is what leads me into the question about the supervision of the execution of judgments, because there you will have a similar situation. So how it works. The court delivers a judgment. The judgment is binding on the state, but the court doesn't have the power to ensure the implementation of the judgment. That power is given to the Committee of Ministers under Article 46(1) of the Convention. And Article 46(2) says that the final judgment of the court shall be transmitted to the Committee of Ministers, which supervises its execution. There is a very particular situation when the judgment concerns the EU. Now, the judgment, there's a binding obligation on the EU to implement the judgment, and that obligation is not discharged until the Committee of Ministers say so. So pretty much any decision which the Committee of Ministers takes in the context of supervision of the execution of judgments has legal consequences for the EU because they determine whether or not the obligation to continue taking action to implement the judgment persists. Now, Article 218, paragraph 9 of the Treaty on the Functioning of the European Union, when you read it, it's not obvious, but in effect, it requires the EU and its member states to coordinate their positions when voting in the Committee of Ministers on decisions concerning the execution by the EU of a judgment to which it is a party. What this means that when the Committee of Ministers takes decisions on the execution of a judgment by the EU and its member states in Brussels will decide what their common position is, and this position will then be expressed as 28 votes in the Committee of Ministers, the 27 member states in the EU, because the EU will participate in the Committee of Ministers when it supervises the execution of judgments. Those 28 leave 19 non-EU member states, immediately a minority. And there are even certain decisions that the Committee of Ministers, procedural decisions, can take by a simple majority. So procedural decisions, the EU gets its way. The EU and its member states vote, and their 28 votes carry the day. Any other decision requires at least a 2/3 majority, and the non-EU member states will never be able to achieve that on their own. So 2/3 of 47 is 32 for voting purposes. The EU cannot achieve that, so it can't take these decisions by itself, but it can stop them being taken against its interests. This is a huge problem because the court's judgments are not self-executing, because the court doesn't have the power to enforce the implementation of the judgments. Anything that needs to be done to provide redress at domestic level to the applicant, to provide compensation, what they call just satisfaction to the applicant, or to take measures to prevent repetition of the violation for possible future applicants, so to address systemic or structural problems within the EU legal order, or with any party's legal order. These require decisions by the Committee of Ministers. And in a sense, this is where the convention system meets reality. It's where the judgments have effect, and it's supervised by the Committee of Ministers. And it has to work effectively. So it has to be able to work objectively and neutrally for the EU, but also all of the parties, all of the Council of Europe member states and the EU have to be treated equally and fairly. One cannot imagine, for example, that the UK or Turkey or Switzerland or Norway or Liechtenstein or San Marino or whoever is going to be happy continuing to be part of a system in which their voice is diminished or completely neutered when it comes to supervising the execution of judgments against the EU. And the EU and the member states have a decisive influence in those cases. That would be legally and politically intolerable. So the negotiators had to find a solution for this. There was a solution in the 2013 agreement. It was, I would say, incomplete, and it was to some extent based on an assumption of good faith and goodwill by the EU, to the extent almost that the EU was being expected to refrain from pursuing its own self-interest in the Committee of Ministers by not taking position on its own cases, because of the fact that if it took position, this blocking majority would automatically come into effect. When we came back to the negotiations in 2020, one of the member states said, we need to revisit this provision. The situation in the Committee of Ministers has evolved. Voting is more frequent. And this means that there's a greater possibility that there will be voting on cases involving the EU. Now, it has to be said that voting is extremely rare. Most decisions are adopted by consensus. But it's also true that when there is voting, it's not on the easy cases. It's not on the straightforward cases. It's on the cases that are most difficult to implement, where states are having the greatest difficulty doing this, either because maybe there's disagreement on what has to be done, or because there's a political reluctance to take action. And the political reluctance may reflect extreme political sensitivity. And those are the kind of cases that can't be left in suspense or forced through by one party, because it has to have this advantage. If you look at the cases, for example, in which the Committee of Ministers has referred a judgment back to the court because the Committee of Ministers considers that the state has refused to execute its judgments, those have been judgments concerning politically motivated detention of opposition politicians. And these, on the domestic level, on the level of the state's international relations, for media purposes as well. These are individual stories, they're very easily told. These are the cases that have to be dealt with according to the standard and objective and effective procedures. They're the ones where voting happens. So I was kind of thinking about going through the provisions of the accession agreement in some detail to explain how this is going to work. I think that maybe will be too detailed for the time and would take too long for the time. It may be that Zoe will be able to do some of this tomorrow. She was there during the negotiations. She helped us to develop these ideas, and she has as good an understanding of how they'll work as I do. And she also has a much better understanding than I do of how the Committee of Ministers works generally when it comes to execution. But I would just repeat the fact that, to my mind at least, this was one of them, I think okay, put it this way. From a Council of Europe perspective, I think this was the most important issue. Because it's not a question of what do we need to do to make things work for the EU. From a selfish Council of Europe perspective, the EU could have acceded to the convention without a special accession agreement. It could have done it the same way that any state acceded. You deposit an instrument of ratification or accession, and then you make the necessary internal orders to comply with the requirements of the convention. Ideally, you do that before. But this is not something which is the subject of a special agreement. Maybe there are reservations and declarations and so on, but no other state has had a special accession agreement. And that could have happened. And all of the problems would then have been in Brussels and Luxembourg. But from our perspective, from the perspective of the court, from the perspective of the Committee of Ministers, that's not our problem. But accession wouldn't have happened. It simply wouldn't have happened if there hadn't been this agreement. So there is this agreement. But from a purely Council of Europe perspective, what will create problems is creating this voting bloc in the Committee of Ministers. So, like I say, from a purely selfish institutional perspective, this in a way is more important than anything else in the accession agreement. From a third-party perspective, maybe not. I think from a Council of Europe perspective, this is really fundamental. And it had an even more peculiar dynamic in the negotiations because there was less obvious an EU bloc, because this only favours the EU. It doesn't favour the EU member states. They don't benefit from this. A judgment against France or Germany is treated in exactly the same way as a judgment against Norway or Turkey. It's only the EU which benefits. So the EU bloc was a little bit, you could kind of see some cracks there. It was definitely non-EU member states. We can't allow the EU to accede and then have this advantage. Yeah, this peculiar dynamic, I'll come back to that. But I think as a final point, and this applies to absolutely everything, and it's been made before, whether to find a solution to this Committee of Ministers voting issue, or solutions for the co-respondent mechanism, joint responsibility, prior engagement, there was really very great commitment, willingness, political engagement, determination, imagination on the part of all of the negotiators. They never gave up. This was very impressive because I would say expectations in 2015, just after the Opinion 213, expectations in 2020 after the President and Vice President had written asking to reopen negotiations, there was no certainty that all of these problems would be solved. There was a lot of goodwill, but there was no certainty. But the negotiators really never gave up. All sorts of things were tried. Things which in the first place did not seem promising, or things which were initially presented as pretty much necessary and in the end were dropped. It was a very interesting process. So, yeah, there's what may look like a degree of compromise, but I don't think anything has been stretched too far. As Professor Katenides said, I think the advantages to individuals of being able to bring cases against the EU or being able to see the EU join a case as a co-respondent will be far, far greater than the procedural inconveniences and complications of having to deal with some of these new processes. So, yeah, I hope that when it happens, all of these things will work themselves out in the application. But certainly I remain convinced that the reasons that Christos at the beginning gave for going through all of this over the course of decades, these are still valid reasons and they still make the whole thing worthwhile.
David, I know you're tired, but we still have 2 more hours. No, I think we'll wrap it up here. But before that, any comments or questions addressed to David? No. No. I will just make one comment. And, good law should apply under all circumstances.
We cannot hear you.
Yeah, thank you. Thank you for this reminder. Yeah, good laws need to apply under all circumstances. And the concern is, and this goes back to the point that Vasilis and myself in the paper we co-authored with Demi Franklin also made about the question of good faith. If all involved actors, the EU, member states, the courts, domestic courts, the Court of Luxembourg, etc., they have this spirit of good cooperation, loyal cooperation, sincere cooperation, and good faith, then I'm sure there are going to be solutions. But there is always this possibility that in the future, because of their own self-interests, states, the EU, they may abuse this. And this is where we will face some problems. And there is always the case that the European Court of Human Rights also tries to get more than what is given to it. You already mentioned the example of, proceedings in order essentially to review the decision of the Commission as to whether the correspondent mechanism should apply. And we know that the court doesn't lack imagination. The same way that it invented Bosphorus, it can invent another test to tell us when and how, and confine the power of limit the power of the Commission to decide when the correspondent mechanism applies or not. Having said that, we know that there is no perfect agreement. This is already a very complex environment, and is a major achievement that we have this agreement. So I think we all in this room very much hope that there will be a happy end and a marriage in the end, and never a divorce. So I think with these words, I would invite us to join me in applauding all speakers and thank them for their contribution. And Paris, you appear relieved. I think everything well. Yeah. So thank you all so much, and we will continue tomorrow as scheduled. Okay, thank you.